So, good morning and welcome. Welcome to our September Unity Conference. Really excited about today. We've got some great speakers, some really important subject areas that we've all got lots of questions about. And so we're looking forward to a great day. So you can see on your screen at the moment, we've got Alex Cook, who's going to kick off the day for us. After I've just finished a few introductions. So if you're, I'm just trying to manage you from here at the same time. If you're coming in and you see yourself on the screen, just go down to the bottom of the screen and stop your video. So what we do is we bring everybody into the screen with their videos and their microphone between speakers, where we go for our traditional Unity cafe style chat, where people can chat amongst themselves and virtually network. Of course, we were hoping that October would be the first month that we get back together with physical meetings, and I was looking into the challenge of how to actually combine a physical meeting with the meeting format that we've become used to since March. But it looks likely that that's not going to happen this side of Christmas with everything that's going on at the moment. The other thing, if you hadn't been keeping up to date with the news, is we should be expecting an announcement from the Chancellor this afternoon. So that will be some interesting stuff, and maybe subject of one of the cafe chats later on, once we hear what he has to say about additional support for people due to COVID. One thing I'm expecting from this is an extension of the capital repayment period on the CBILS and the bounce back loans. So it could be that the actual monthly payments halve from what they currently are planned to be after the first year. So that'll be interesting. So let's wait and see about that. We're kicking off with Alex Cook in a moment. You can see him on the screen, and I'm going to start to chat with Alex in a second. And then after Alex is finished, we'll have our standard cafe. And then at 1 p.m, we've got David Toon coming on for a question and answer with me for about 20 minutes, half an hour, but also to take your questions. And David is a specialist in the EICR regulations, and also he's an electrician that goes out and does EICR tests. So if you've got any questions or anything you want to know about EICR, about remedial work and everything with regard to that, then David's the person to save your question for. Following on from that, at 1:45, I'm having a similar question and answer session with Gareth Clarke. Gareth is, again, a very experienced expert on EPC and energy efficiency. And Gareth will be questioned on current EPC situation. We'll take your questions on EPCs, particularly those potentially who may be coming up for a renewal of an EPC and what they might expect. But also we're going to be talking about the energy grants that are available and are likely to become available for landlords in the future. So I think that's going to be quite interesting to see what we might expect with regard to potential grants coming up. And then finally, we're going to talk to Stefan Daines, who is a chartered insurance broker. Not many people out there who are chartered, and Stefan is going to talk to us and answer my questions on legal expenses insurance in general and rent guarantee insurance specifically. And the reason that I'm keen to have this compliance stroke insurance theme today, following on from what Alex has got to say, is obviously we're all a bit concerned about the future. We're all a bit concerned about what happens if tenants don't pay rent. And of course, by ensuring that we've got good compliant buildings in place, and also taking any risk management actions that we can in order to de-risk our current business would be certainly worthy of consideration at the moment. So in between all of these question and answer sessions and chats, we'll go back to our Unity Cafe format, where everybody can pitch in and chat and just enjoy the networking and enjoy the day. So that's great. I've looked at the forecast here in Loughborough. We're raining from 1 p.m. until 4 p.m. So dog walking can take place a little bit later, so we can enjoy the conference in the meantime. So, Alex, hi, you're looking very smart and very homely
Hi,
as well.
how you doing?
Yeah.
Well, it's funny, isn't it? Everyone, you all have certain expectations of solicitors, so I don't like to disappoint. You know, notwithstanding we're virtual here, but yeah, kind of, you know, I thought I'd break out the shirt and tie. It's quite rare these days, but at the same time important sometimes. So, yes, here I am. Good to be here. Good to be here.
And really grateful to have you, because at the moment I imagine life is pretty busy with you and many inquiries and many issues that could be a lot more difficult to deal with than previously.
You know, it's a funny time, and you know, for a lot of reasons, we're kind of the traders in misery, and you know, I'm pretty transparent about that. We deal with problems, as you know, and disputes, and so you know, really, in trying to resolve those problems, yeah, that's our business. Unsurprisingly, I think for most people, there are quite a lot of issues floating around. Today, we're going to focus on possession aspects for landlords, but you know, broadly, just taking a step back, money claims, investor disputes, these are areas where, yeah, there's a lot going on. There are problems, non-payment issues arising. It's not just landlords who are sort of facing that, but you know, ordinary businesses, commercial landlords, investors, etc., are all sort of there or thereabouts, having similar problems. So yeah, I mean, look, cutting to the chase, there are problems out there, and you know, that won't surprise anyone.
Right. Well, while Alex brings up his presentation and starts to talk to us, can I just say to everybody that if you can hit your chat button at the bottom of your screen and get that chat box up, it would be great that you could share your own experiences as landlords while Alex is talking, and let us know, you know, through the lockdown, whether you've seen an increase in rent arrears, tenant issues, and everything else. Let's have a good read of your own experiences. And of course, if you have any questions for Alex, pop them in as you think of them into the chat box, and we will come back to you at the end of Alex's presentation and start to bring you on screen to ask those questions. So, brilliant. Without further ado, Alex, over to you.
Great. Well, look, thanks, Rupert, and sort of, yeah, morning, everyone. I suppose I've obviously put on screen and shared in front of you sort of the headline, as it were, for today, just really focusing on, in particular, residential issues for landlords, investors. We know that the world is uncertain in a lot of ways at the moment. Lockdown has created issues. I think it naturally increases the risk and the fear more than anything for landlords, investors, of problems. And that sort of feeds into what, if anything, can you be doing, thinking about now to try and just avoid problems in the future, or position yourselves on the front foot, really, if you do need to deal with anything moving forward. So these are really the focal points for me
Alex,
today.
sorry to interrupt you for a minute.
Yeah, go on.
Your screen share, and I think because the whole of your screen is shared rather than the presentation on itself, then there is an email box that is showing. So I don't know if you're able to close.
I can't see that. So where's, is that my unread email?
Share off. So when you go onto the share, it ought to give you the opportunity just to share the presentation. But
yeah, and it has. So let me just try that again. Let's give it a go. Bear with me.
In the back of your system, there must be an email screen open, which is very frustrating for you, I'm sure.
Hang on a moment. So I don't have any emails open now.
Okay, if you try the share again, and we'll let you know.
Let's have a look.
That's perfect now. So the gremlin has gone.
Can you see just the screen in front of you, the first slide, or can you see all of them on the left?
You can see them all on the left-hand side. So you might.
Okay. So if I go, if I do that, how does that look?
Perfect. That's exactly.
Yeah. So we're back. Good.
Nice.
Thanks for that, Rupert. Okay, so as I say, focal point for today, really, residential. I would just emphasise, for the purpose of today, you don't need to take any notes. The notes will be completely available at the end. There's some hopefully useful links to government guidance, forms, current versions, etc., which are kind of embedded in the notes. So all of those are freely available at the very end. So don't worry about all of that stuff. As Rupert's mentioned, if you do have any questions, chuck them in the chat box. That's absolutely fine. I don't have that open in front of me right now. It just sort of avoids losing track. So I'll pick those all up at the end, save them up, and look really happy to kind of give people a steer. So kind of just moving forwards, items I'm looking at today with you all, really kind of, I suppose, three aspects. And this, I think, Rupert, you hit the nail on the head about risk and how do we mitigate or reduce risk? Well, firstly, back to basics in terms of compliance aspects, everything that you need to be thinking of. I'm a huge fan and use myself, agents, no question. I think they're primarily a time saver for a lot of landlords, depending on expertise, experience. They can be fundamental in terms of compliance. But no matter how much experience you have, I think it's important to say, even if you use an agent or you are an agent yourself, the buck always stops with the landlord. And so, I would strongly advocate that any landlord investor has a high degree of baseline knowledge, the sorts of things that you should be thinking about or aware of at any stage in a tenancy, just so that you have that degree of spider sense on risks in your own portfolio, perhaps certain tenants, etc., because nobody will care more than you. So a degree to which, just going to touch on the basics, that I would expect that the court would demand, would require if you do hit problems further on. And then secondly, types of claims. So notices, what you might be thinking about. And, again, this can very much vary from tenancy to tenancy, claim to claim, and tenant to tenant. So, there are lots of variables in this: money claim, possession claim, either, both, factors that you might want to think about. And obviously part of that, we know, coronavirus, just a complete swathe of legislation, almost incessantly, changes to notice periods and what have you. So I'll obviously give you all an update on what the current position is right now. Of course, I'm going to caveat that significantly by saying this is all subject to change. And that perhaps leads into the third item, just to wrap up my section. In terms of longer term, where does this leave us now? What do I think the general direction of travel is in terms of landlord and tenant disputes moving forwards? So those are really the headlines sections that I'm hoping to cover today. But as I've said, if you do have any questions, make a note, chuck them in the chat box, etc. And Rupert will pick up on those as we go along. So just very briefly first, who am I? I am a solicitor. I'm a litigation solicitor. I specialise in dealing with property litigation. I act for investors and landlords. I've mentioned here that it's hundreds of evictions. It might even be more that I've either acted in or have supervised for well over 13 years now. So that's just a little bit about me and Helix Law, a firm that I own. So that's us. So let's launch into this, back to basics. A little bit of perspective here, okay? We are all naturally in a heightened state of concern at the moment. We don't know what the economy is doing, where businesses might be leading. I think it was important just to take a step back because what we don't want is for the fear to be greater than the reality. And what I'm really trying to encourage here is sort of fact-based thinking in terms of those concerns. So it's right to say, as a starting point, that the amount of time that claims will now need and will require is significantly longer, okay? So claims are serious, but it's also important, I think, to say that they're relatively rare in terms of the overall numbers. In fact, I would say very rare. And again, I've put some numbers here to assist everyone just in terms of this perspective point. I think, and this is a best guess, but I think and expect that claims will now take in the region of 12 to 18 months, a long time, granted. But I've also mentioned here that, in terms of the PR and the narrative that we see publicly amongst basically the marketing aspects of other organisations, shelter, generation rent, etc. As a percentage of overall PRS, or basically private landlord households, we know that the percentage of those tenancies that require a claim, we're looking at 2%. Now that's obviously pre-coronavirus, and that will, I would imagine, and most would say, increase the number of claims being necessary. But even if they were to double, you're still talking about 96, 98% of tenancies not needing a claim. And again, I think it's just, as I say, trying to take a step back, take a deep breath and understand where this sort of fear fits in overall. The vast majority of landlord and tenant relationships do not require a claim, okay? And so hopefully that sort of just allows everyone to sort of appreciate that and to, as I say, take a breath. I've included at the bottom there just some links to the data that I sort of rely on in reaching those conclusions. So it's not kind of hot air followed up by hot air. That really is the core data for everyone to have a look at, if you like a dull read, just as I do. So as I say, a bit of perspective. So compliance. Now, again, I have seen people speak about sort of, oh, this wouldn't happen if I were the landlord, or, I wouldn't have this, that, and the other. And I from my perspective, again, I use the words hot air. This can happen to anyone. Okay, that's my experience. It's not a bad landlord or even a bad tenant that can lead to a claim. In the majority of cases, that there can be some tenants who have a high degree of knowledge, and this is always their sort of MO. They've teed the landlord up for a claim or a dispute. But actually, and again, the majority of disputes that we deal with, it's an unfortunate chain of events that has led to this. And so compliance as a starting point, it's not optional. But even if it were, prevention is better than cure from your perspective as a landlord investor. So how do we start to position you in the best position if you do have a dispute, if you need to take steps moving forwards? And that begins before you even agree any tenancy, okay? So I refer to this as compliance, but I actually think it's almost just good business practice if you're dealing with tenants. Again, just gleaning as much information as you possibly can. And as a matter of course, previous addresses, employment details, both current and historic to the extent that you can, bank statements, requesting those if you can, next of kin family details, national insurance number and vehicle details. Why am I suggesting all of this information? Again, if we say fast forward, tenant hasn't paid or can't pay, you're looking at some sort of an arrears claim. One of my sort of first immediate questions or conversations with you will be what your prospects of actual recovery are. And so there are lots of different ways that we might, number one, obtain a judgment, but secondly, enforce that judgment. In other words, force payments if someone ignores the CCJ. All of this information, which you can obtain as kind of your process on, as I say, just at the very outset, the kind of, if you wanted to view the property, I'm going to need, or yes, you'd like to move forwards, I expect and need these documents from you. Hard build that into your process at the outset. Because obviously, that is very useful in enforcing judgments moving forwards. Talk about employment details. That opens the door to what's known as an attachment to earnings order. Bank statements, that opens the door to what's known as a third-party debt order. National insurance number and vehicle details assist with both tracing, and also bailiffs might want to recover against that vehicle in due course. So what I'm really trying to do here is position you at the outset so that at the end, if you do have, say, a rent arrears claim or a disrepair claim, a money judgment, you can look at this information again with a view to whether or not that will help you recover the money. So again, hardwire that in at the outset. You can bet your bottom dollar that if you need or ask for that information later when there is a problem, you'll never get hold of it. So again, before any tenancy, obtain as much information as you possibly can, just with a view to later on if needed. It may sound like common sense, and for many of you, particularly with agents, it will be, but obviously contact employers, seek reference details, double check the information that is being provided to you. I've also mentioned here, consider third-party referencing. You obviously need to pay for it, but I think the reality here is fundamental. That you're making a credit risk-based decision on an applicant, you need as much information as possible. Third-party data can absolutely form a key part of that. So I consider the fee, the cost of this, de minimis. If you're running this as a business, it really ought to be, it's a key part of your armory in positioning you moving forwards to get your money back if you need to. So these are steps that you can be taking at the outset. I've emboldened at the bottom there, any CCJs or inaccurate information are a cause for a sort of immediate red flag in my mind. Sometimes I'll speak with landlords who they're almost most frustrated at themselves because they'll have had an instinct or a spider sense or something wasn't quite right, and they might not have listened to that instinct, they might not have taken that on board. And I would say to you, again, it's here in black and white, no matter how small a CCJ is or how large it is, any judgment that has been obtained against somebody is a concern. It increases the credit risk that you are taking in taking them on as a tenant, and the risk of default is therefore higher. You might still go ahead, but it might make you think twice in terms of additional steps, be it insurance or guarantor. So, again, sitting here, it should hopefully be a matter of common sense, but if anybody lies in terms of the information they give you, and that comes out as part of your process, for me, that's bad news all day long. You must start this relationship as a commercial one. And if there's any inaccurate information, I'd be running a mile, to be honest with you. So again, prevention, absolutely better than cure. Consider this a credit risk based approach. And those are really the steps, the factors that I would suggest you take into account. So let's move forward. Problem later, these are the baseline documents that I and the court would expect, need, and really might demand to see from you. So we're now in a position where tenancy's moved forwards, it's going on, and you've hit a problem, and that problem might be non-payment of rent, it might be to do with the condition of the property, it might be that you want to regain possession to sell, it could be any of the above or all of the above. These are the documents that you are going to need to provide. And so make sure that you or your agent, as appropriate, have those documents available easily. Again, I would suggest hard bake this into your process when acquiring a tenant or using an agent. Have a Dropbox or whatever it might be that just makes this as easy as possible and not a trauma. Sometimes we can find that we lose time on waiting for X, Y, and Z to be obtained or to be provided. There's friction there. So if we're really trying to, again, position you so that if you have a problem, you can deal with it quickly, make sure you've got these documents in particular bang on, nailed on as to where they are, so that you can provide them. And again, the devil's in the detail with this. So copies of all ASTs, not just the most recent AST, all of them with this tenant from the outset. And an AST itself, again, I'm going to be pushing on an open door here, I appreciate for most of you, but ensure it's in writing, ensure it's signed, dated, clear certainty of terms, the parties. Again, what I mean by that is, who is the landlord? Not, I don't know, Mrs. Jones trading as, I don't know, XYZ properties. Don't just put XYZ properties. Make sure that the legal entity, if it's a sole trader with a trading style, Mrs. Jones, not XYZ properties, unless it's limited. If it's limited, of course, that's different. It's the limited company that is contracting with the tenant. But it really be clear on these sorts of items, because it goes towards notice validity later, validity of court proceedings, and all of that goes towards time and money and clarity. So be really clear and certain on the terms, and be thinking about this for the duration of the tenancy. If you start varying these terms, how do I need to record that in a way that if something goes wrong, there's a clear chronology as to what has happened and there's clear certainty? Might be simply a letter, might be a further contract document, but you really need to be very clear in documenting and evidencing what has gone on in this tenancy, what the core terms are. So that's just one example. Rent arrears schedule, again, should be relatively sort of common sense to most. And then we move into some of the more standard documents. Everyone by now should know about the How to Rent booklet. I've mentioned here as applicable at the relevant date. I have seen, and actually I think particularly agents can be guilty of this, sort of mass downloading or mass printing of a How to Rent booklet so that they've got kind of a batch ready to go and don't have to wait for the multiple pages to be sort of printed on any given tenancy commencement date, I would say to you, don't do that. This is not a document to download and keep in a folder somewhere. You need the most recent one at the date that any tenancy is entered into. And this is a real mess just in its own right. You know, there have been variations and amendments and the documents are not properly dated by government. So just avoid any doubt or risk on that. Just simply go to the website at the appropriate time and download the one at the commencement date of the tenancy. Again, deposits, okay, this is not new. This has been around now for a long period of time, but it's fundamental. The date when the deposit was received needs to be clear in your own mind, the date when it was protected, and that the full prescribed information was provided to tenant with copies. When I talk about full prescribed information, do not be caught out by simply the certificate in one of the schemes. The actual, when you look at the detail of that, the prescribed information is not solely the certificate they provide. There's also terms and conditions that go behind that document. And it's all of those that together form the prescribed information. We need all of that to have been provided to tenant so that we can serve a valid notice on your behalf, or so that you can serve a valid notice on your own behalf, and so that you can issue a claim. And when we talk about issue a valid notice, that notice period is now likely to be, we'll come on to this, but likely to be 6 months. So we're talking about if you serve an invalid notice, you're at risk of losing 6 months to a year before you can even issue a claim. That is the level and the degree to which you now need to be on top of these sorts of items. And again, the advice has to be on this, no ifs, no buts, no sort of, oh, well, it's perfect except for, you know, you really need to be ticking these boxes, dotting I's, crossing T's, or there's always going to be risk of delay, of additional cost of time, money, etc., being leaching away. So yeah, make sure, particularly deposit information, but these other items are covered. Gas safety certificates, again, you know, I think this forms part of a broader conversation, but, you know, I notice routinely that the court forms change as well as notices and all the rest. The court forms actually require these documents to be provided, even though in theory the civil procedurals that govern claims don't need that. But now, you know, we as landlords are asked to go further. You have to provide these documents. So you've got to have them available, you know, copies of gas safety certificates annually from the outset and moving forwards must be available. So make sure you have them. EPC, self-explanatory, make sure it's valid and in date. License, if as applicable. So obviously I'm here talking about mandatory or selective licensing as applicable. You need to ensure that you've complied, that you've applied, that you've dealt with any conditions. And, you know, again, this has an impact on the validity of notices moving forwards, if not. So is again fundamental. A couple of these other items might be slightly surprising or things that you don't sort of immediately think of. We're always very interested in any complaints received from a tenant regarding the condition or the repair of the property and your replies. This goes towards retaliatory eviction. Again, you may be aware of this, I'm sure most are, but retaliatory eviction is a circumstance where, say, a Section 21 notice seeking possession is served by a landlord after the tenant has made a complaint in relation to the condition or the repair of the property. That is unlawful and that notice will not be valid. Again, you might lose 6 months. The way that we deal with that and prevent this from being considered by the court as a retaliatory eviction is by ensuring that you have given an adequate response to any complaints received in writing from tenants on the condition of the property. An adequate response is what we're going to do and by when. So it's pretty limited, but really, again, there's a degree to which we're box ticking here to try and prevent later problems down the line in terms of the validity of notices. So we would ask for any complaints and your responses to those, or your agent's responses. And again, I suppose if we're keeping an eye on our own investments and we're instructing agents, we need to be making sure that when they are corresponding with the tenant about X, Y, and Z issue, they are confirming what they're going to do on your behalf and by when. And that's really the test as to whether or not a response is adequate in terms of a disrepair allegation or anything that might just throw a slight sort of a break in the link in terms of validity of notice later. So that's what we would be looking for there. Copy inventory, I mean, this goes towards the condition of the property and whether or not tenant has acted unlawfully in their treatment of the property. So not so much say for arrears, but obviously condition must be evidenced at the outset, particularly if you're later going to try and pursue damages for a condition of the property. We probably know, but fair wear and tear is not allowable. So there's a degree to which the condition may have decreased, and we're talking about any losses that you have suffered as a result sort of going way above that in terms of a claim. You need your inventory to support that. And then a guarantor agreement. Please try and obtain guarantors. That is amongst the most useful step that you or any landlord investor can take. Not always available, I appreciate. But if you can get hold of a guarantor, particularly a UK property owner, that's what I'm really looking for on your behalf, that really can shift the whole dynamic, including of a possession claim, because it really puts the guarantor on your side of the fence in sort of contacting the tenant and trying to encourage them. It's additional leverage, but encouraging them to leave. So guarantor agreement, and I guess a minor point in some ways, but something just to look at, particularly if, say, your agent is providing a guarantor agreement or you're using a standard-ish document. Make sure there is a costs indemnity in there. That is a clause, as it were, that requires the guarantor to indemnify you as the landlord in relation to your legal costs. And again, that's invaluable because it just means that you can be saying to the guarantor, or I can on your behalf, this is really painful. It's going to take 12 to 18 months, but ultimately we're going to be coming after you, guarantor, unless tenant leaves or unless X, Y, and Z happen. And you can just immediately see how it means you have someone on your side, on the inside of that relationship. And it's very different to a situation where you might have, say, a tenant who is sort of head in the sand. You have no real information or contact with them. You don't have any links where you don't have a guarantor. It can be really frustrating and difficult to get behind that type of head in the sand approach. Whereas if you have a guarantor, they know it's their problem. And the big thing about guarantors in relation to landlord and tenant residential, say arrears, is that arrears for landlords might be considered significant at, say, I don't know, £5,000 would be a significant rent arrears claim, and possibly even less. It can put landlords in difficulty. But in the context of owning a property, to have that amount of equity is highly likely. Depending on where you are in the country, it is almost certain, scary words to use, but almost certain, that there might be equity at or about the level of rent arrears, assuming they're commercially modest at those levels. So really shifts the balance. So again, make sure you have these documents available, make sure you're considering this at the very outset, and then we can move quickly, basically, on your behalf if we need to. You can move quickly on your own behalf if doing it yourself. So we've got this problem, we've got our documents, we've looked at all of these issues at the outset. Factors that I would be looking at in terms of giving, say, you advice on what steps to take. It might be that tenants in arrears, they're not treating the property well, but you're concerned as to what steps you might take. Well, it's all well and good talking in the kind of, the abstract about different types of claims, but these are the things that I would be trying to just draw out in a conversation with you. What's your priority here? Is this about money? Is this about possession of the property? Is it about both? Are you looking to sell? So for some landlords, actually, they're pretty relaxed. They might have a guarantor. They don't really want back possession. It might be difficult to re-let, but they do want the money. And so that might lead us towards a money claim rather than a possession claim, which we can come on to. Whereas for others, and probably most common, it would be possession or both, and the money is used as a means to regain possession. But that's not exclusively the case. And particularly now, I should add that money claims have never been suspended. So we've been issuing money claims right the way through lockdown. The courts have never stopped issuing money claims, and there's sort of a public policy reason for that. So possession claims have been suspended, and we know that the sort of the ban has been lifted, and the claims can now continue for possession, but they were never suspended for money claims. So again, it goes into the mix. Does the tenant have any assets or means? Typically, but not exclusively, but typically tenants won't have assets. But again, if we sort of take our minds back to the list of factors just way up at the outset of any agreement with a tenant, some do, and particularly in, say, I don't know, city properties, etc. There might be work reasons, it might be only for part of the month they're there, or whatever it looks like. Again, if a tenant has assets, that is a significant factor that goes towards the steps that you might take that might be in your interests. We might prefer to say obtain a money judgment quick and charge their property and even try and force the sale of their property, all with a view to increasing the pressure on getting them to agree to leave and getting you repaid. So again, it's slightly sort of, it's a very individual issue, this, as to what the position is. Will a CCJ have real value for you? Again, it's part of the same conversation, really. Does the tenant have any assets or means to pay? Or is this really going to be good money after bad? Is it really about you regaining back possession of your property as quickly as possible? Because ultimately you're going to end up with a CCJ that they owe you perhaps thousands of pounds with costs, etc. But they can't pay it. And for a lot of landlords, that will be the position. So what is the value of a CCJ for you? Are there any factors with the tenant? Some tenants, believe it or not, in these circumstances, they work in financial services and they won't want a judgment on their record. That can impact their employment. And for others, it will impact their ability to lend, as we all know and appreciate, in terms of having CCJs, etc., with others. So, is that a factor in all of this as well for them? Can we be making threats or taking steps with all of that in mind? Question mark. The third one is really an item that I'm encouraging everyone to try and deal with and avoid yourselves, which, invariably it can crop up. Sometimes your options as a landlord are more limited because you have not dealt with compliance issues, or an agent on your behalf has not dealt with compliance issues at the outset. What do I mean by that? If you've not registered the deposit, for example, you're not going to be able to serve a valid Section 21 notice straightforwardly. There are steps we might take to improve your position on that, but that's the starting point. And so that leaves you with a Section 8 regardless, or a money claim. You don't have the option of a Section 21. So are there any factors that we need to think about there? Is there a risk of a tenant bringing a claim against you? So again, have there been any allegations of disrepair, property, etc.? I'd encourage you to think about that, because ultimately one of the risks with a Section 8 claim, which is a claim based on a breach or a fault by a tenant, is the risk of a counterclaim. We see this increasingly, commonly, again, across the country, where you as a landlord will have what appears to be a bang to rights rent arrears claim, but then we face a counterclaim for, I'm going to use the word spurious, not always, but often spurious allegations of disrepair. Someone's not opened a window or ventilated, there's a little bit of mold, nobody's bothered to wipe it, the whole thing becomes blown up, etc. Is there any risk of that type of counterclaim? Because if there is, that is a factor as to whether or not to pursue a Section 8 type claim. I mention it here because there is no ability to counterclaim a Section 21 based claim. So again, if there's no risk, if nothing's ever been intimated, if the property is immaculate, then the reality is a Section 8 counterclaim is likely to be low risk, but it's still possible. So that could be a factor. I've already mentioned, is there a guarantor? If there is a guarantor, I'd probably suggest a greater degree of patience in the kind of pre-issue of a claim period. Simply being that we can normally put the guarantor under incredible pressure to achieve your aims, whatever that means, recover money or recover possession, simply because of the onerous impact of a dispute, a claim on them, if the tenant doesn't ultimately play ball. So is there a guarantor? Another factor. And then obviously finally, do you have any applicable insurance? Rent guarantee insurance, any other form of insurance that might assist you here. A quick word on insurance. It will, hopefully again, common sense this, but the moment you hit an issue, you need to report it, okay? And you need to ensure that you're taking appropriate steps in accordance with your policy. The requirement, to notify insurers and the failure to notify can be a reason for insurers to decline cover. So make sure that you are acting in accordance with your policy, and perhaps have a conversation with your broker early on, just with a view to the steps that you might take, the evidence that they might need. I suspect it's going to be very similar to the evidence that I would need and have asked for in earlier slides, etc., in terms of a claim. But obviously, if you've got it, explore using it ASAP as soon as there's a problem. Moving on. So we need a claim. We fast forward. A money claim. A money claim is, as it appears on the tin, an AST at its heart is a contract, okay? And the tenant is obliged to pay you rent, and you're obliged to provide them with accommodation. So one of your options where you face, in particular, non-payment of rent is to look at it as a contract in isolation and not to deal with possession. And that becomes relevant for the reasons I've already mentioned, i.e. the long period of time that possession claims now take, and depending on the different sort of local lockdown or any lockdown too that might happen, the fact that money claims have been able to continue. They've never been stopped or paused, as I've said. So that makes it more attractive, in my view, to look at a standalone money claim in certain circumstances. What are the outcomes for you? Well, it results in a money judgment, a CCJ against the tenant. That will clearly be visible on the tenant's credit record. Most won't want that. Some won't care, I should say, but most won't want that. And it can be enforced by you for up to 6 years. Again, I'm sort of, perhaps it now starts to fit in terms of the context as to why this is relevant. But tenant assets can be enforced against if they're in property, bailiffs if, say, they have a vehicle, attachment to earnings, which is a deduction from their wage if they are employed. And I haven't put it here, but a third-party debt order. So that's where someone has a bank account with money in, you can obtain a court order that the bank give you that money up to the value of the judgment. So these are methods of enforcement that you can use if you have a money judgment and have pursued a claim in that way. And so that's absolutely one option. You can just look at this as a contract and can look at it in that way. Some of the pros, pretty straightforward to issue a claim. I've mentioned it here, money claim online, pretty cheap, it's online, you can log in, you can absolutely do it yourself. You don't need to instruct solicitors on this. And if it's, say, simple, an unpaid invoice, unpaid rent, frankly, why not? Why wouldn't you look at that? It allows you access to multiple methods of enforcement, which I've listed above. Some of the cons or the drawbacks, it can be ineffective if the tenant is not bothered about a CCJ. You've basically got a piece of paper in your hand with a stamp on it, and ultimately that's not going to lead to money in your bank account. You would need to take further steps to enforce that, and ultimately with money, you might be owed the money, the court might approve that you are owed the money, but if the tenant doesn't have the money or the means to pay, you are not going to get the money. And again, let's not sort of mince our words here. There's no point in false promise, that's the reality. So you do need to think about that again at the very outset when considering whether or not to pursue a money claim. This is a claim in its own right as another potential sort of con or drawback. And that means that the tenant can defend that claim. They can dispute the claim, they can still issue a counterclaim, and you would then, as the landlord, need to defend that counterclaim and pursue your claim right the way through to conclusion. There is no small claims court. This is a common misconception. There is the county court and the high court, and that's all. So where we talk about a small claims court, that's the small claims track in the county court. And that really, it's dealt with, the same law applies to a small claim as applies to a multi-million-pound dispute. There's no distinction. And if you don't know what you're doing and you start encountering a defender or even a counterclaim, then obviously that can be disconcerting, and the same law applies, the same procedure rules apply, and you're losing time and again money in the context of having to deal with that, as well as the stress. So you have to brace yourself for that if taking this approach, because the tenant does have a right to defend and counterclaim. Again, I've mentioned here just in passing that it can impact possession proceedings later. If you're looking at issuing possession proceedings, you can rely on rent arrears. But if you already have a judgment for that money, for that rent unpaid, you can't litigate over that same money twice. And so, because the court have already decided you owe the money, and so it can complicate possession claims later on. So I'd make your decision. Is this about money? Is it about possession? Or is it about both? And if it's about either possession or both, then this is probably not the route for you in terms of just a money judgment. So again, just factor that in to avoid complexity. Other options, and really we start with the heart of it in terms of possession. You have really two options for now, okay? And number one, an accelerated possession claim, section 21 based claim, which is a no fault claim, or alternatively a section 8 fault based claim, which is technically a claim for possession of land. The processes are very different, okay? And just starting with the section 21 notice claim, the notice itself is remarkably straightforward, okay? But we do find that there are routinely errors in the content, misspelt names, wrong address, the wrong period of time allowed in the notice. So You know, all of these are kind of just bear traps you need to be aware of when drafting these notices. Read the guidance notes if you're doing it yourself, and ensure that it's right, frankly. You know, there is no discretion to vary these notices, which I've put at the bottom of the slide. If they're wrong, you're effectively not going to be able to rectify it later. And now, because the notice is 6 months long, you're losing 6 months. In reality, you're losing a year, because you'd have to serve a new one and then issue proceedings on that. That is, again, crippling for landlords who might use these notices even where there is a fault by a tenant, because it can be quicker. So again, just factor this into your analysis on how best to deal with these. And again, there are all sorts of potential bear traps with Section 21s. No EPC, no gas safety. All of these issues can basically mean that any notice you serve is not valid. So be alert to this. I was going to just take us, I'm conscious of time, so I'm not going to, but I've included here a link to the actual claim form. And again, I think this is a really important steer for these types of claims. For those who want to download the notes later afterwards, perhaps click through that link and just have a look at in particular, the evidence that you have to now file with the claim form, because it should really educate us all as to what we should be thinking about at the outset. I've already covered this, but you know, all of the gas safety certificates need to be included with the claim form. All of the ASTs need to be included with the claim form. So you can immediately see that if you're not on top of those documents, you can't include them with the claim form. That's going to just slow this up in the system. It doesn't necessarily mean you'll lose. It might mean delay. And in the context where we're looking at thousands of claims being backed up, you do not want to be a claim just with a slight frisson or issue with it. You want to be completely vanilla to run through that sort of process. So it might be worth you having a quick look at that later. I'm not going to do that now. Section 8 claims. These are claims that lead to both money judgment, so the CCJ, and a possession order. I'm assuming they're based on rent arrears here as a factor. Section 8 claim, it's a fault-based claim, relies on a breach of the AST by the tenant. You have to prove that breach, okay? And this is something that's often overlooked. It's like, oh, well, I made the money, there we go. It's not just a rubber stamping exercise, this. There will be at least one hearing in these types of claims. And of course, that has a knock-on impact in terms of the amount of time that is required for these types of disputes, particularly where we know there are any number of claims being issued at the moment, thousands. So again, just factor all of this into your analysis. You will absolutely need to attend court, probably virtually at this moment in time. You will absolutely need to file a witness statement. Are you comfortable dealing with that? Do you know what I'm talking about when I'm mentioning these aspects? But that's a key difference with, say, a Section 21 claim. There will be a hearing. It may therefore take longer. I've already mentioned the counterclaim risk. So you might have, say, a claim for, I don't know, £3,000 at the rent of £1,000 a month, 3 months worth of rent arrears. The tenant can counterclaim against that for disrepair. It doesn't matter at the outset whether or not that claim has any merit. It could frankly be made up. That will delay your claim being dealt with, because the court have to treat it with a degree of seriousness, might require expert evidence, someone going and reporting on the fact that it's immaculate, etc. You can just see how you will lose time if that approach is taken. So that's absolutely a risk. We already know pre-coronavirus that Section 8 claims were taking in the region of 6 to 12 months. And the obvious reality is they're now likely to take a lot longer than that. So these are longer form types of claims. And this, by the way, almost in passing, is one of the consequences of banning Section 21s. You will lose your accelerated possession claim. This will be your only option. It will take longer. One of the reasons why the banning of Section 21s is so difficult for landlords. Again, I think if we just take a step back in the context of coronavirus, there's lots of public policy reasons, arguments to slow claims down at the moment. And so I would expect, say, the listing of hearings to be considerably longer than you might imagine. It could be 3 months until you get a hearing. Just at the outset, it could be longer in some courts. So just bear all of this in mind when thinking about it. And this is sort of part of the decision making for landlords and part of the kind of risk analysis at the very outset of tenants in the current world that we're in. Coronavirus, right. So for those of you already familiar with Section 21, Section 8, etc., what is the current position? There have been a number of changes in the last, well, since March effectively, on notice periods. I've included them here. Long story short, where are we at right now? Well, We were 2 months at the outset for Section 21, 14 days for a Section 8. We are now for both at 6 months, meaning the notice period is 6 months. There are some exceptions, okay, and in particular for a Section 8 notice, where we have, say, certain criminal conduct, rioting, domestic abuse, antisocial behaviour. Notice period significantly less with those. But importantly is this 6 months arrears date. The notice period is still 4 weeks, but you can serve a Section 8 notice where the arrears are over 6 months, and it's a 4-week notice period, not a 6-month notice period. Now, on the one hand, that's good news, and I think anything that improves our position at the moment is to be welcomed, and so that's one sort of win we'll snaffle up. A couple of warnings on this, which it's always applied with Section 8 notices. The test for a mandatory possession order, particularly on ground 8, which is a ground that needs to be relied on in a Section 8 notice, is that the arrears need to be at least or more than 8 weeks or 2 months, both at the time of service of the notice and at the date of the hearing. Question: what happens if the arrears are over 6 months at the time of service of the notice, but we then fast forward to the hearing and the tenant has made a significant payment to reduce those arrears below that 2-month period, which has not changed? And the answer is it would then become a discretionary claim and the judge would not have to order possession to you. So again, if you're looking for a mandatory possession order based on Section 8 notice and arrears within that notice on ground 8, keep in mind the tenant can always make a payment to bring those arrears below the mandatory threshold. That was the case before coronavirus. It remains the case now. The good news with that is that you would obviously receive a significant payment, so you've got money. But the bad news is you could go through the litigation process and not regain possession of your property. So again, just keep that sort of frisson in mind when looking at this, and in particular, I suppose, in managing your own expectations as to potential outcomes. So that's the current position in relation to notices, 6 months, unless you fall within an exception. Many landlords will fall within that exception, as I say. Included at the bottom here a link to a guidance document that government have issued. Again, I was going to take us to that. I'm not because of time. Long story short, there is a huge public policy push at the moment for everyone to take a reasonable approach, to not be too aggressive, to try and have dialogue with tenants, to try and reach agreement with tenants, even to mediate with tenants. There are all sorts of buzzwords being thrown at us. That guidance is quite a long document. I'd encourage you to have a look, not least because it gives you a steer on current thinking and the general direction of travel. More on that in a moment. But at the same time, be really clear on the fact that, ultimately, unless you have a tenant who has left, any agreement is not going to be binding on them, just as the AST is on paper binding on them, but they can breach. If you want them out, the only time at which you can be confident they're gone is when you have back vacant possession. And this goes towards, if you reach a deal with someone to stay in a property for a certain period of time, don't say completely disregard your claim. You might need to reinstate that claim. They may breach that agreement. And there's no sort of judicial recognition of an agreement for a tenant to leave. It's not binding. So you won't get a possession order by consent, is what I'm particularly saying. A tenant can't agree to leave and then the court will make an order. It just doesn't work like that. So just be very careful around reaching an agreement with a tenant in that context. The process, again, there's a coronavirus impact, as it were. I've mentioned on notices, but we also have on process. Existing claims, an awful lot of landlords they already had ongoing possession claims in the court process, and they've been stuck basically in limbo since March to date. Nothing is going to happen automatically. If that is you, then you need to take proactive steps to basically reactivate, as it's being referred to, that claim. Now, this requires specifically you to send to the court and to the tenant as well a reactivation notice. I've included here a link to the practice direction that details this, but long story short, you need to be setting out what knowledge you have or is known about the impact on tenant and their dependents, if any, of coronavirus. This again, just for context, there's no legal rationale behind this. Okay, this fits into buying the courts and the local authorities more time to process these claims. That's the only reason for this. And the reason I say that is that a judge will have no discretion if you're relying on a Section 8 notice on ground 8. And if the Section 21 notice is valid, the judge won't have any discretion on that basis either. So this reactivation notice stuff is really about buying time. So put yourself at the beginning of the queue, deal with it nice and early if you haven't already, and get your claim being processed ASAP. The other point to make, obviously, is you might not have any knowledge, and invariably, if a tenant's got their head in the sand, you're not in contact with them, that's not going to wash. So again, we tick the boxes, we jump through the hoops, we move on, and so reactivation notice is important. Where your claim concerns rent arrears, you must provide an updated rent account for the previous 2 years. Again, fundamental. And again, just a slight nuance on this. If directions have already been made by the court, you need to file a copy of that with new dates with your reactivation notice, as well as confirmation on whether or not you're happy with a virtual hearing. And I would say to you, always confirm you have a virtual hearing. It will fundamentally mean you're dealt with more quickly. Almost all hearings are now taking place virtually via Zoom equivalents, etc., Skype for Business. So, get on board with that. Easier for you, easier for everyone, quicker. So virtual hearings. Court process, again, just briefly on this as a final point. If you don't deal with this by the end of January, your claim will be automatically struck out. So this is not a situation where if you have an existing claim, you can do something or just sit back, wait for something to happen. If you don't deal with this by end of January, your claim's going to disappear, it'll be struck out, and you'll have to start all over again, new notice period and all the rest. For new claims, touching on this, you have to confirm your knowledge of the impact of coronavirus on the tenants and their deposit and their dependents, very similar to existing claims. And you must also, with the Section 21 accelerated claim, serve that knowledge on the tenant and with the court. So at the very beginning with those types of claims, with the claim form, and with Section 8 type claims, you need to deal with that both or either at the time that you issue the claim or at least 14 days before the hearing. So slightly different approaches there, but long story short, coronavirus is being considered, but it doesn't actually impact the legal tests, which is why I say this is really about buying the court's time more than anything. So conclusions, okay, leading in. I would say to anyone, you need to expect claims to take significantly longer. 12 months plus is the new norm, okay? And that applies regardless as to the type of claim. You need to plan and budget accordingly and to expect the process to actually change. I think there will be further changes and the formalities to increase. That is the public policy at the moment. We're buying the court's time, but we're really buying local authorities' time in terms of rehousing people. So, this is the game, these are the rules of the game, we have to play to them. I would always say again, consider trying to reach an agreement with a tenant to leave, because claims are only required if there's no agreement. This is your other option. So is it worth approaching the tenant and saying on a without prejudice basis, meaning off the record, will you enter into a deed of surrender on these terms? And I would say, as frustrating as it is it appropriate to think about a rent write-off or a reduction, or something along those lines, given the cost in time and money to you moving forwards of obtaining a possession order? You're perhaps doing other landlords a disservice, as many would bring to my attention, which I'm already aware of, but I only act for you. You have to keep a close eye on yourself. And some landlords, they might be at risk of losing their property. Desperate times, desperate measures. There's all sorts of impacts. So I think it's absolutely right that you look to see whether or not you can reach an agreement with tenant. Again, that's being publicly encouraged. But just make sure it's on your terms. So there's no write-off unless they've actually left, meaning you've got the keys in hand. And record the terms in a deed of surrender. This is a formal document. I would expect an agent to have one readily available, and it just formally closes the tenancy, brings it to an end. You have that in hand, nice clear evidence. You get the keys back, you're out of it. So always look at that as an option. Couple of final points, really. I've already mentioned guarantors, so I won't touch on that again. But again, historically, I think the perception of landlords has been, I had a really long void. I'm sort of minded to take a slightly higher risk tenant to kind of hedge that gap and avoid the void. I think the balance on this has now shifted markedly, in that, from my perspective, on your behalf, a void is far more preferable than a bad tenant if we're going to use those sorts of terms. And so I'd be very cautious about taking credit risk at the outset in any of these situations. So, you know, the impact of possession claims, it's never been taken longer, and it's never been potentially more significant on landlords, as far as I'm concerned. And then just finally, kind of to bring things to a degree of conclusion here, longer term in the future, I fully expect that notice periods as they are here to stay for at least, I mean, I can't see things won't change until March, and I actually think longer term this is likely to be the new norm. The court process, again, there's a degree to which this is unknown at the moment. We've had 6 months during which there have been no new claims issued. And we know that annually there are approximately 100,000 claims issued. And so there should be, just on normal run rate, tens of thousands of claims backed up. That's before we think about the impact of coronavirus on potentially increasing the value or the number of claims required. So more complexity and formality in the court process to kind of, forgive the term, but flatten that curve in terms of the number of claims is highly, highly likely. So I expect claims to be more complex and to take longer, fundamentally. You need to keep a close eye on compliance with the validity of notices, because as I've said, if your notice isn't valid and it's a 6-month notice and you only become aware of that at the end of the 6 months, that is crippling. You're losing a year. You have to serve a new notice. Mediation. So mediation, okay, and it's not just in housing, it's not just in landlord and tenant. Mediation is a form of trying to encourage people to reach an agreement, okay? We use it a lot in bigger scale disputes, commercial disputes, and it's a fantastic process. As a landlord, you need to be aware of the potential risks, namely that I've just touched on. If you reach an agreement with a tenant and the tenant remains in situ, that is not legally binding. So I would always say, as a starting point, as a landlord, you really want any settlement to kick in at the point where the tenant has left. And if that's your aim, then I would strongly encourage you to steer for that and trying to position yourself for a settlement. So that's what I mean by saying beware. A settlement or an agreement is in writing via mediation. It's just another version of your AST. You're still going to need to pursue a claim. So, yeah, just keep that in mind. Housing courts, well, they may kick in. You know, I think there's going to be a lot of pressure on the courts and a lot of pressure on government to impact this moving forwards. Have a look at it. Housing courts in Scotland, the experience has been that they have significantly delayed possession claims. So I'm afraid I don't have much sort of positive news to report on that front from a landlord's perspective. I think it will ultimately take longer if they do implement it. And we all know that the abolition of Section 21s is coming. It's bad for landlords, but it's bad for tenants. You know, local authorities will not have an obligation to rehouse a tenant who loses a Section 8 fault-based claim. And so ultimately that could increase homelessness. That is not what anybody wants. And that's one of the impacts. So I do think that sort of Section 21s, particularly in the current environment, there's a lot of kind of anti-landlord type rhetoric out there. I do think there's a high probability that they will be abolished at some point in due course. So that's where I'm at. Apologies for kind of whizzing through that. I've mentioned here, slides are downloadable. There are some links to forms that hopefully will be useful. By all means, click through the link afterwards. I kind of wanted to open it up to a Q&A whilst I take a breath, and no doubt you all take a breath as well, but I'm happy to field any questions.
Brilliant, brilliant. Thank you very much, Alex. That was very, very informative, and some great slides there, which we will put up in our files vault as well for future reference. And of course, this has been recorded, so this will be on the Unity YouTube channel as well for future reference. And you'll find that your audience will massively increase over the next couple of weeks as people join and have a look at that video, which is commonly the situation. Yes, I was going to ask you if you could stop your screen share now, then we can actually see the people who are going to join us to ask questions. And I'm going to bring Carol into the room if that's all right, because Carol's had a couple of questions earlier. So let me just, are you here, Carol? Are you?
I've beaten you to it, I think.
Yeah, well done. Yeah, we can't see you.
Oh, hang on. How's that?
Good, brilliant.
Oh, there you are.
It's nice to see Alex in the flesh, so
And
to
you.
speak, after such a long time.
Yeah, how are you, Carol? I hope you are.
Not too bad. All my tenants are predominantly behaving. Just
Good.
relet a couple. I had a couple of questions that I'd
Fire
put
away.
into the message box.
Okay.
I've just got some tenants moving in tomorrow and they've got guarantors. So I've got the deed. That's all been signed. Prior to them, they've seen the tenancy agreement and everything. I've even met them and done a right to check their identity and everything and check their house. So that's ticking all your boxes, I think, for that one.
Sounds good. Have you got a land registry office copy for that as well, for the guarantor's property?
Yeah, I did a £3 download.
That's the one. Yeah, perfect.
I do it with anybody that's a guarantor.
Yeah.
So I think I've covered all that. I had an interesting one. There was a chap that was interested in a different property, and I did the standard NLA because I use all the NLA paperwork. So I'm hoping that the NLA agreement's got the monetary order thing you were talking about on
Yeah.
it.
Yeah. I think, is that the cost indemnity?
Yeah, that was the cost indemnity.
Yeah.
That was it.
Yeah. Really valuable. Really valuable.
Well, it's valuable that they've actually got a proper form for it, because it used to be you need to mention these bits, put it together yourself.
Yeah. No, not good.
So it used to be a bit daunting, but the fact they've now got a new agreement that's watertight is great.
Yeah.
You talked about applicants and certain professions not wanting to have a CCJ or legal action against them. Is there a list of professions that one could find?
Do you know, honestly, not that I'm aware of. I would say anyone working in a financial services environment, and that can even include people like, bank cashiers, it would impact them. Anyone with, dare I suggest it, a legal sort of interest or career, it would be disclosed potentially. And it's kind of relevant from a professional regulatory perspective. So dishonesty is very seriously dealt with in terms of solicitors, accountants, surveyors, because we're holding client monies. So I would say if you're dealing with anyone as a potential tenant who holds client monies, that would probably be a good starting point. That's not to say that rent arrears result or arise because of dishonesty, but if people are going to say file a defence no merit, then it could be, and it's just additional leverage. That's really where I'm coming from with it. So I think all of this goes into, you're taking a credit risk when taking on a tenant, and it's just the extent to which you might have angles to play if you need to later down the line. But it sounds like you're doing a great job, Carol, and fitting in with the kind of, as I mentioned at the outset, the reality is that the number of claims, it's not as high as people might assume.
Well, that's it. I keep ranting on about it at council meetings and stuff, but I think I'm slowly getting the message across, but it's taking time. And the good thing about the tenant with the guarantor is she's just completing a master's in law in February.
All right, okay, good. That doesn't
which
mean
I
much.
liked. She wasn't necessarily top of my favour list, but when she said she was doing law, it was like, ooh.
I mean, Carol, and I'm sorry to kind of pour water on the fire for you, but I've seen some part-time law students who can just be an absolute nightmare. They're chucking all sorts of stuff at you. But anyway, I hope that's not your.
No. She actually comes. She's actually taken. She's done it while working part-time, so she's put the graft in for it, and she's looking to go into the CPS, I think.
Right.
So she's got her head pretty well screwed on, and they all seem pretty screwed on.
And would not want to.
Well, you can't tell, but I've done the best.
There's another little point on this, actually, just that might help others and or you, which is that if and when you have a CCJ, if you're owed money, you can also look at bankruptcy. And I wouldn't normally suggest this because ultimately that's thankless. You're an unsecured creditor. It incurs costs, it takes time, but the reality is it is still an option to bankrupt. And if, for example, a CCJ doesn't concern people, the threat and the impact of bankruptcy often will. So again, we hope we're never in this world. We hope we're never in this position. But if we find ourselves owed a lot of money, it can form another just tool in the armoury.
Well, another one I had was a while back. I got a CCJ against a tenant that owed me money, and it all went through against her and a partner. And I anticipated that they might get in touch with me because they were still they were still together. It looked like they'd separated. They were back together and they were living down in London. But I wasn't sure if I've just got the CCJ, does it automatically go against their file, or do I have to do something?
Well, okay. Again, classic question this, and a good question. If you've issued if you've obtained the judgment via a Section 8 notice, then I would always say write to the court.
No, it wasn't via Section 8. It was, I did
claim.
it MCOL.
Yeah, so if you've issued a money claim online for everyone else, or an MCOL claim, then that should be a judgment, and after 28 days it will be registered. You have a period of 28 days after a judgment is obtained against you, because if you then pay the judgment, it will never be registered, because effectively you might have had a legitimate dispute. Whereas if you've not paid it after 28 days, then a money judgment will be registered, yes, absolutely, and will appear on credit files.
Right.
So how do you find out if a judgment is registered?
It's actually a company, bizarrely, but it's called Registry Trust, and you can run a search on Registry Trust as to any registered judgments. I think they do charge for it, and I don't know the fee, but I think
it's about £8.
It's equivalent to the land registry. It's not commercially significant, but I would also say, periodically, say you get a low value CCJ, it's not paid, you don't really want to be throwing good money after bad. It's difficult. You've done your bit for other landlords, and are happy to sit tight with no doubt a degree of relief. You've got your property back. I'd say, key date after a year, 18 months, run a trace. You can trace a tenant for, I think, £35 plus VAT I've seen on the internet, if not more, or slightly more or less, but there or thereabouts. And see, because quite often they're sort of find an address, run a land registry search. Circumstances change. We've had tenants contact us where we've obtained judgments, and it's years later. They now need that CCJ satisfied, removed off their credit rating because they want to get a mortgage. So it's very much a long game, and I don't see the value of a money judgment necessarily in a short-term kind of dopamine hit success. We're going to get a check.
It's been quite a few years, and I've just sort of sat there and not really done anything. But now I'm thinking maybe I should follow it up.
Well, I mean, look, nothing ventured, nothing gained. As with all these things, I wouldn't spend huge amounts of time on it. But yeah, I mean, they could be employed. All sorts of things could have changed.
They were both employed in good jobs beforehand, and they'd been model tenants, but they just had a relationship bust up. She left, he fell apart, and then he might actually have had to go to prison because I think he assaulted a policeman, but he won't have known about it because I got all the court papers and he didn't because he'd left the property.
Right. Oh dear. Well, colourful lives. What was I going to say? I mean, I think on that, there's another form of enforcement that you might consider. So again, just imagine a world where we've traced, they don't own a property. What are their circumstances? We think they've got a good job, as you mentioned. In those circumstances, you could look at what's known as an examination of judgment debtor. And this is another type of enforcement whereby basically tenant has to attend court and complete an information form of their assets, their income, their liabilities, etc. And all of their bank accounts, for example, vehicles, employment. So you get a lot more information, and if they don't do that, then that's contempt of court, that's a criminal offence, etc. So it's got a little bit of teeth behind it, and you can then just use that information to inform you moving forwards. So an examination of judgment debtor could be of use to you there. Just a watchword on that, Carol, and that because it requires attendance of court and because of coronavirus, those applications are on a massive go slow at the moment.
Right.
You're looking at into next year. So it's not, as with all these things, there's a degree of friction, but it's an option.
If you trace them, would it be seen as a bad thing to send them a letter with a copy of the judgment against them?
No, absolutely nothing ventured, nothing gained. But again, I would always say, be careful you don't spike your own guns with that. Because if they've moved, they might think you're off, they're off your radar. And if you start writing to them at that address, they're going to be like, oh, okay, let's not park the car nearby. Let's, do X, Y, and Z. Let's move.
Well,
So
I had to do a trace to do the MCOL because they disappeared off the face of the earth. So that's why it was a surprise to find them together at the same place.
Right. Yeah.
And my last one, I think it was the last one of what I'd raised, is that it's a sort of a little bit of an interest for everybody. I had a couple that were interested in renting the place. She was fine. Him, again, it was your thing about the gut. There was just something that wasn't quite right, but everything seemed to check out. And then I did a credit check on him with the NLA system, and they couldn't find him, so they couldn't give him a credit rating. And yet he had an phone bill. He lived with his brother in a rented flat and paid the water bill by direct debit. He had a bank account. He had a car loan. I got him to do a check on my file, and of the 4 providers, only one could identify him with that address, which I just thought was a bit.
Yeah, I mean, Caroline, again, if we just take a step back, what are we doing as landlords? We're basically entering into a credit relationship with these people. That's what's going on here. And what's that worth? Well, it would be worth at this point in time thousands of pounds. You know, no matter what the rent is. If we're talking about 12 to 18 months of non-payment to regain possession, you know, so are you happy to lend that person money if we try and get our heads into the credit risk mindset? And the honest answer is no. You know, you need to know who you're dealing with. You need to know what skin they've got in the game, because you've obviously got a lot of skin in the game in the property. You know, what's your leverage if something goes wrong? And if that person could just disappear, not good.
So his dad was going to stand as guarantor, but his credit check came back very similar as well. So it's sort of like,
And do you know, Carol,
but he was a homeowner. I did check that one.
Do you know, that is an invaluable point to make, though, which is that, you know, there's no magic in a guarantor. It's simply what we're trying to do is reduce credit risk. And so we're hoping and assuming that by somebody being pitched as a guarantor, they have assets and means to satisfy any credit risk we're taking with the other person.
I always do a credit check on them and do the land registry check to make sure they are the homeowner and there's no funny restrictions or like on the title.
Yeah, I mean, look, I think that's absolutely right. And I'm not sure you can do much more than that, truth be told. But again, I have seen situations where people have said, oh, well, I've got a guarantor. And then, of course, you run a check on the guarantor and the guarantor's worse than the tenant. And you think, hang on a minute, we've missed an important step here, which is that the guarantor is supposed to improve our credit risk. Otherwise, it's pointless, you know.
Yeah.
But just taking the point about the guarantor, my understanding is that the agreement or the arrangement with the guarantor is not Housing Act protected. So you can actually say to the tenants, you can carry on not paying rent or do what you like, and I'll just, you know, CCJ your guarantor. You don't have to go through that same Section 8 or 21 situation.
Yeah, well, again, so I think this goes towards what we're trying to achieve, because you can do that, but then you won't be able to regain possession. So if you want to regain possession, you're going to have to serve notice on the tenant.
Yeah.
But I mean, yeah.
But on the money side of things, you can just literally keep going to the guarantor through the civil courts, and you're not involving the more arduous procedures that are laid down to protect.
Absolutely. And it's all leverage. That's the way I see it commercially. You know, if you've got a bank to rights guarantor you can pursue, they're going to be turning the screw on the tenant, and that's the real value in a lot of ways of the guarantor agreement.
What was great is the guarantor's property on the check that you do actually gives you some demographics, and the value in that area is 230 to 250. So I'm thinking, yeah, that's fine.
Yeah.
So I'm going to bring Sue into the room. She has made some comments and also had some questions.
Right. Thank you for that, Alex, and
No
nice
problem.
to see you face to face.
And you. Thanks, Carol.
Hiya. Hi,
Hi,
Alex.
Sue.
Sorry, no camera. What questions did I ask, Rupert? Sorry.
I'm looking back up the chat now. Can you hear me?
Yeah, well, I've just posed one. I'll start with that one.
Yeah, the abolition of Section 21 and the impact on council rehousing is massive.
Yeah, it's the first time I've heard this, because we've always seen it as a negative, i.e. that as landlords we would lose Section 21, but I hadn't realised that actually we can turn it against the tenant in some ways, because often they're angling for being rehoused by the council, and they seem to think that they're going to get a perfect little council house by walking away from yours, and they will step into a nice little council house with a picket fence and roses over the door. Yeah. Whereas, of course, they're going to go into some kind of temporary housing first, but they don't believe that. But if that is being severed now with the abolition of Section 21, that's massive. That's the first time I've heard of that.
Well, just to be clear, that's a natural consequence. So there's nothing being severed, and this goes towards council or local authority obligations, statutory obligation to rehouse. And there are really two important terms here. On the one hand, you have voluntarily homeless, and on the other hand, you have involuntary homeless. Okay. Now, the local authorities, as matters stand, only have an obligation to rehouse where someone is being made involuntary homeless, i.e. the person, the tenant, has no role to play in their lack of accommodation. In those circumstances, the local authorities step in and they have an obligation to rehouse. And as you say, they're imagining a cottage in the countryside with a nice garden and all the rest. And the reality is it will be temporary accommodation in a B&B or something, at least for a short period of time, unless people fit into, say, they've got dependents or what have you, and they'll try and do more. Or a disability.
I'm interrupting, but have we inadvertently been giving them those council houses by wimping out of using Section 8, when Section 8 is in law more appropriate? I understand about the arguments on Section 8, but have we all these years used Section 21 because it was easy and cost us thousands in taxes?
Yes.
Jesus Christ, I had no idea.
There's no question, because, yeah, and it boils down to the individual, doesn't it? As in the individual landlord. An individual landlord will say to me, okay, I can pursue a Section 8 claim, I can issue it, and I'm talking pre-coronavirus, okay, so I can issue it quickly, I can get a judgment, but I risk a counterclaim.
Well, you've said it yourself many times, Alex, haven't you, that, go for Section 21, I recommend Section 21, get your possession, argue about the money later.
Quicker,
right? But
simpler,
what we're doing
cheaper.
is doling out council houses to people who ought to be CCJ'd. And we've been doing it for years.
I'm not sure about that, because an awful lot of those people they'll move, they'll go back into the PRS, and there's another argument there, which is around the impact on other landlords, which I can readily accept. But I think we've got to just understand the full context of this, which is invariably in circumstances, particularly where there are arrears, the advice wouldn't just be to pursue a Section 21. It would be to pursue a Section 21 to regain possession more quickly, and then to issue an MCOL claim for the arrears when you also know the damage in the property. So that's more readily what we would have said pre-corona.
But they've been rehoused by then. They're in the rehousing loop.
But I mean, people are going to be rehoused. That's we don't want to see an increase in homelessness. That's not good for landlords or for tenants.
But the council is no longer having to rehouse any tenants, because with the abolition of Section 21, there will only be fault evictions.
Yeah, I mean, at the moment, see, one of the difficulties is we don't have all of the detail on this. And if you were to ask the housing minister, they would say, oh no, we're going to make changes to other aspects to prevent that, or we're going to change this, that and the other, and there's just a lack of certainty on it. But cutting to the chase, I mean, in principle, I think you're absolutely right that there is going to be, and you've got to bear in mind, 65%, a high percentage of possession claims are issued by local authorities and housing associations. Most, by far, possession claims are issued by local authorities in this way. So we shouldn't be hugely surprised that they are also angling to try and reduce their obligations to rehouse people because they're under pressure. And I think really, if we try and just take a step back from the enormity of that realisation, the point is the banning or the abolition of Section 21s, if it comes, is bad for tenants. You know, that's really the conclusion. It's
It's
not
been
good for
aimed at
tenants.
landlords, hasn't it? It's been, you know, everybody, even, you know, people like the NLRI, you know, them, and and all the journos have all talked about no fault evictions, you bad rich landlords in your mercs.
Yeah.
And nobody has hit, you know, this is the first time I've heard of this. It's,
Yeah.
I get
No,
now.
I'm trying, see, I'm trying.
Yeah.
It's, yeah, I mean, look, it's funny actually, because I was talking with a journalist about this yesterday, and I think there's something coming out either this weekend or soon about this, which I'll post around. But yeah, I mean, look, it is what it is. And unless they start changing with the statutory obligations on local authorities, which they might, you know, that could be another outcome. But unless they do that, yeah, this is bad, bad for tenants in terms of Section 21's going, no question. Yeah.
Well,
Interesting, Alex. I'm sure that a lot of people who are suffering this and listening and considering the situation get tempted from time to time to take the law into their own hands on this matter. And whilst I know what your answer is going to be if I suggest, should we just get some heavies round? But if you were, for example, to have an HMO where one of the tenants had chosen not to pay rent and you just had this issue, is there anything that could be done if, for example, you were giving basic facilities, amenities to that particular one, but you were giving a higher level of facilities, amenities to those that pay rent? In other words, you were in some way disadvantaging them or sanctioning them for not paying rent. Could that be seen, and I don't have a clear example of this, but let's say, for example, technologically, you could actually give a very low level of internet usage to the non-paying one and a very fast internet usage to all of the others. As an example, could that work against you in court if you were to do something of that nature?
Okay, good questions. Let's just start with the kind of unlawful stuff. I've dealt with landlord, you know, this year, okay, and the last 6 months who, you know, aggressively took steps to basically change locks and do X, Y, and Z to resolve the issue, okay? And the first they knew about the next steps that were coming at them was that an injunction landed on their desk or their home through the post, and there's a hearing next week. There's already been one hearing. The claim has been issued, and they arrive at my door only about, I mean, it's you know, 3 weeks later. It's pretty quick. You know, this is pronto. Legal aid solicitors, legal aid barrister instructed by tenant, completely funded by the taxpayer, no tenant involvement, got to allow the tenant back into the property or breach the injunction, and on the hook for £10,000 worth of costs, and the claim is still continuing. And it's, you know, talk to me about whether or not that is a good decision in those circumstances. Because, you know, that landlord is saying to me, but I'm going to lose this property. I'm in mortgage arrears, I've got all sorts of problems. I don't have that money. You know, I could probably scrape that money together to dissipate, to deal with this completely, but, you know, that's me. And I'm saying to them, that won't be enough. You know, you've now created such a problem that, you know, it's tempting in desperate times. And I really understand that. But commercially, taking the business rationale behind that, trying to cut the emotion out of it, this is not good business, you know? And it's like you're putting stuff on red, as far as I'm concerned. You're taking a massive gamble, because I grant you, some tenants won't be savvy enough to go and get legal advice. They'll go to their mates or they'll go and rent another property and you won't hear from them. And so in that sense, I do understand, you know, the need, the imperative behind this. But I have to say to you, when it goes wrong, it goes badly wrong, you know, and that landlord is now in a real bind, you know, a real bind as to how even, you know, we can hit the reset button on that process to get them back in without them having a massive bloody nose. You know, that really is the position they're in. Putting that to one side, your second point, just in terms of steps you can take, I think you've got to be very careful, okay? You've got to be very careful in terms of when you talk about basic amenities, what are we talking about? Are we talking about an Xbox that you put in the communal area? Or are we talking about gas, water, basic sanitation? you can't be touching any of those issues, okay? And to the extent that you are in breach of your own contract, you might be putting yourself at risk of losses resulting from that. So there is a degree of risk. That said, I don't generally dislike the kind of the approach. I think, it's not a free-for-all, and particularly with HMOs, there's a degree of sort of communal space and area, and therefore control over that space that you can exercise. But you do need to be very careful that you're not touching the basic kind of heat, sanitation, hot water, and contractual items that you've agreed to provide. You'd say to me, but they're in breach, why do I have to keep doing that? And I'd say, at the end of the day, all of that is very interesting, but you don't want to have to pay me or do it yourself in front of a judge to explain why, what you've done and why, and you don't want to suffer any further time as a result of doing that in terms of delays and what have you for further hearings. So on the one hand, emotionally, it might satisfy to, I don't know, turn the tap off or tone down the internet and what have you. Be very careful in terms of not breaching your contractual obligations and not creating a rod for your own back later and dragging out the court process, having arguments over that.
That's fantastic, Alex. That's and I'm seeing more and more people getting, venting this frustration from that point of view. We've got a guest in today, Tara. I'm not sure if you're still listening or around. She said we are owed thousands by one tenant who has no assets. There's nothing we can do to retrieve any money from them. Well, Tara, I hope that having listened to Alex today, you slightly amend that statement. So there is something you can do, but it's going to be a long haul, and it's very frustrating at the moment.
Yeah. Agreed. Tara, happy to speak with you afterwards, but the reality is, again, hindsight's a wonderful thing, and I recognise this. People are in dire straits sometimes. The time to really deal with it is at the beginning. That's the key, really is. Yeah.
And so that's been absolutely fantastic. Is there anyone else in the room that'd like to ask Alex any questions? I know that he's an extremely expensive person generally to get hold of, so this really is a great opportunity if you do want
Lies.
No, and on that, I will give Alex a bit of a plug actually, because I'm not very generous with recommendations. I'm happy to give referrals. I rarely give recommendations, but I have used Alex's service at Helix Law, and although Alex did email me on a number of occasions, it was other members of his team that dealt with the matter, and the communication was second to none. I was very, very impressed with the manner of communications, the updates, and the fact that I was given the formal choices with a sort of a bracketed, if I were you, I would take this choice at the end of each of the emails. So I was very impressed. So if you find yourself in this position, I would recommend that you contact Alex.
Thank you.
It ain't going to be free, I'm afraid, but on the other hand, you're going to get your possession, or you're going to achieve the best result that you can.
Rupert, I'd have to concur with you. Alex helped me out big style. So didn't necessarily like everything he said, but reality and the courts don't necessarily work as you expect, but we got there in the end.
He did a wonderful job for me, one of which wasn't a property claim, but I've had a couple of possession claims and a family thing, and all marvellous.
Mm-hmm. So
thank you, Gareth.
Apart from thanking Alex very much for his time this morning, we'll go shortly into the cafe mode, so people can bring themselves into the room and chat generally. I did agree, given that this came through the post unexpectedly the other day, so I've agreed to give it a plug. I must admit, as you can see, it's not very thumb turned at the moment, and I haven't had a chance to read beyond that. So I can't tell you what it's about. But this particular book by Shaz, who spoke at our last conference, is on sale today, from today, on Amazon. So I said, oh, well, that's a good coincidence. I'll plug it today at our conference. So just to let you know about that. For those of you who are not Unity members, then welcome, and I hope you're enjoying the day. We've got plenty more to come further down the line, and please get involved with the cafe and chat about. The only thing I ask is that if you're not a Unity member, consider giving us a go. I've popped the link to all the benefits and how to join and everything in the chat. It's £28.50 a month. You can stop the membership whenever you want, so you don't have to keep paying. And for that, you will get access to our Slack forum, which means that any questions that are asked, that you have to ask, will get answered, and normally answered by qualified professionals as well. You'll get access to our legal expenses insurance, which includes the tax investigations cover, which again is an important aspect of the membership. And later today, we're going to be talking to a chartered insurance broker about legal expenses insurance generally, and about rent guarantee insurance as well. So you'll get to understand a little bit more about what the value of the legal expenses insurance that comes with Unity membership. So give us a go, and then you can join us at future conferences, as well as the weekly cafe chats that we have, as well as being involved with the daily forum that we have on Slack. So having plugged Unity membership, I'm now going to open the gates. So if people would like to join in on the conversation, it's currently just 12, just 6 minutes past 12 now. Our next formal part of the day is at 1 p.m. So we've got 50 odd minutes before David Toon comes on and talks about EICRs. So this is our opportunity to join in a general chat, get your coffee, get your lunch or whatever, and then continue the day following the networking at 1 p.m. So once again, Alex, thanks so much for your time. I really appreciate it. And if you're happy to sit around, I'm sure that there might be others want to mention things in general chat.
Absolute pleasure. Thanks very much.
Yeah, brilliant. So there's now normally, I'm going to stop the
I can't see a lot happening, but
I think people are just grabbing a bite to eat and a cup of tea.
Absolutely, and they're also listening.
Because we overran.
That's another thing. I'll be back in a few minutes, I reckon.
Hi.
hello.
Hi, David. Hi, and welcome back, everybody. It all went quiet, I know, and thanks for joining us, David. It goes quiet just at this time while everybody goes out and grabs a sandwich and gets a coffee and everything else. But we've had a great session this morning with Alex, and so we'll just let people rejoin us. Just bear with me.
No problem.
And we'll make a start. So, okay, we just started the recording again. So, welcome back, everybody. And we're very grateful to have David Toon with us today, this afternoon. And David is going to answer any questions that you've got, and we're going to have a little chat mainly about EICR, but about anything really, anything electric really. David, perhaps first of all, you could introduce yourself and you know, your background, David.
Yeah, no problem. I'm Dave Toon, Electrical Services. I'm just a sole trader. I started off life as an engineer. Actually, I spent many years being an engineer, and retrained as an electrician about 15 years ago now, and then took the leap, went on my own, and I've been doing it ever since. So work's been good, life's been good, been doing various things, mainly domestic, some commercial as well, but I'd say 90% of my work's probably domestic. And with COVID hit, that was obviously a bit of a shock for everybody. But then since then, obviously with these EICRs coming in, and now been made a legal requirement, then there's a lot of landlords out there that are realising the importance of them. So I guess the main part of what you guys want to talk about is the EICRs. But if you've got any other electrical questions, then fire away.
Brilliant. I'm sure that we will be. I noticed there's a bit of an electrical storm going on in the background there. Or is that your virtual background? I think you know.
Yeah, no, that just follows me around.
Now you're from.
It's just the rooms are tipped, so they're missing the background.
Now you're from my neck of the woods. Unity members are from all parts of the country, although there's quite a few in the East Midlands and West Midlands area. How far afield do you travel to work then?
I've done work, mainly Leicestershire is my main, like you say, main neck of the woods is Leicestershire. But quite often I go Nottingham, Derby, Coventry's. But I said majority of my work is Leicestershire based.
Well, you've just pulled in about 10 members by saying those few towns at least. So you're covering a greater area of membership from that point of view. So just talking about starting with the EICR, and by the way, everybody else, please pitch into the chat with any questions that you've got here. So are you able to just bring us up to speed? Obviously EICRs have been around for quite a long time, haven't they?
Yeah. Well, they used to be known as the periodic inspection. Yeah. And they re-termed it the Electrical Installation Condition Report, EICR. But it's the same thing ultimately. It's what was a periodic inspection. They've been around a long while. I think people that have got HMOs probably know more about them because they've needed the fixed wire testing for HMO. It's been part of that legislation for quite a while. It was sort of June the 1st this year that they made it a legal requirement for any landlord to bring it into general rented properties, and that's long-term, short-term, whatever the rental is. You know, it doesn't just have to be a rented property that you've got. That it can be Airbnbs, it can be all that kind of stuff. So anything that's rented, it covers. They've brought it in, and they've actually brought it in quite, I think, quite hard and fast in a way. I mean, electricians have been wanting to get it in for a long while. You know, we've got gas safeties that have been around for years now, and they've been a legal requirement. And electricians and the electrical sector has been saying, well, you know, electricity is just as dangerous, if not more so, because, you know, at least gas you can smell it. Electrics, you only smell it, it starts burning. You know, it's in some ways it's even more so. But what used to happen is there was no legal requirement. So electricians would constantly say to landlords, it's not a legal requirement, but it would fall under the duty of care. So if you had a tenant that had an electric shock or anything happened electrically and it went to court and all the rest of it, the first thing you'd be asked is, what did you do to prevent this happening? And if you had no paperwork, no nothing, you haven't done anything then. You've not looked after your tenant. So it would fall under that sort of duty of care to the tenant. If you've got a bit of paperwork that says, well, I did have it checked, 2 years ago or whatever, then they'd say, oh, okay, well, you are, taking it seriously. But obviously now they've brought it in and said, no, it's a legal requirement, and that's that kind of thing. So I don't know what you guys sort of know about it, but if you have a change of tenancy, you have to have one in place before the tenant actually moves in, the new tenant moves in, and you have to actually give that to them as they're moving in. Now, there's a sort of a twofold thing with this. One is the councils are demanding it, so they're saying that paperwork needs to be given to the tenant. They need to see it, and all the rest of it. And if they're not, then you can be up for a fine. That's one thing, and then the other thing is, I've lost my train of thought. What was the other thing? The other thing is,
was it to do with evicting tenants, perhaps?
Yes, yeah, that's it. You got it. Yes, a lot of the letting agents are saying that if all the paperwork isn't there, so if you haven't got your EPC, your EICR, your gas safeties, if all of those are not in place, and obviously the contract, if all of those are not in place, if you ever want to get a tenant out, then you're in real trouble, because their solicitors will just pick on one of them and say, well, you've not given the correct paperwork, you've not given the correct, folder of stuff, and that's it. You're in you getting them out will be an absolute nightmare. So, it's sort of quite important in the way things have gone.
And there's some confusion amongst some people about the dates as well, because you've already mentioned that this needed to be in place by June of this year. And one wondered through coronavirus whether that would have been extended, but it wasn't. But there's also another date, isn't there? Is it April of next year as well?
Yeah, so what it is if you've got an existing tenant that's been with you, a long time, few years, whatever, then you have to get the report done before April the 1st, 2021. Okay. Now, if you've got a tenant that had moved in before June the 1st, but their contract, you start off with your 6-month fixed contract, and then it goes to your monthly rolling contract after that. Well, they're saying that you should have it in place by the time the monthly rolling contract comes in place. So, because they're saying that the actual contract has changed from your 6-month fix to your rolling, so it's a change of contract, so it needs to be in place by then.
Or indeed, if you just changed it to a new tenant.
Yeah, or at any time, if you change to a new tenant, then like I said before, you've got to have one in place for the new tenant to move in.
And of course, with the service accommodation, Airbnb, of course, you're changing the tenant all the time, aren't you? So. Yeah,
but that is only applicable for the 5 years and the first change of tenant, if you like. Right. So you'll still get sort of a grace period, but you won't have to have one done for, Airbnbs, they can have, 2 different people in 1 week going in there, but you won't have to have one every week or every month or anything like that. You get the first one done, and that's a 5-year.
Okay. So if you haven't changed your tenant before June of this year, you've got until April, as long as your tenant doesn't change, you've got until April of next year. But otherwise, you should have had this EICR done by now already.
Yeah, absolutely. And when you have these EICR done, I think what a lot of people forget is it's a report. Okay, so there is a minimum requirement of reporting. As an electrician, I have to at least look at 20% of any particular circuit. So if one circuit's got 10 sockets on it, I've at least got to look behind 2 of those as a minimum to make sure that the build-up of the circuit is, as it is. That's the minimum, but you can always stipulate that you want more than that. I mean, it's up to the person ordering the work to say, well, you know what, I want 50% of it doing, or I want all of it doing. I mean, yes, it'll take a lot longer, it costs a lot more, but if you wanted it, you could ask for it. doing more is not a problem. You can't do any less than 20%, but you could do more.
I wasn't aware of that. That's interesting. So, you know, you've still got that sort of inherent duty of care risk, I suppose, even if you had the EICR done, you know.
Yeah, absolutely. And what I was going to say is that you've got to read the report. it's what a lot of landlords forget. They get the report done, and it is only a report on what's there. It's not that the electrician's going to fix it. You know, they're just reporting on what is there, and unless it's a category 1 fault, which I'm sure we'll get to in a minute, but if it's a category 1 fault, which is basically something that's out and out dangerous and is going to electrocute you, you know, because there's, I don't know, bare wires hanging out or whatever, then I can't leave it like that. I'd have to isolate that and a very, very minimal, make that safe. But all the other faults are left, because it's up to you then to say, okay, well, I need to get these fixed. So the reports themselves, they're normally over 6 or 7 pages. A lot of it won't mean anything to anybody. It's just, you'll look at it and it's just, you know, it gobbledygook to most people. But normally it's on the second page. There's one box that says comments and something, or the recommendations, I think it is, on the installation. And that's the box you need to read. That's the box with the faults on it. So there, on that box, it'll have all your what's a C1, C2, C3, F1, whatever, and they're the things you need to read.
So with regard to the legislation, then obviously we're clear about when the reports have to be done by, and of course we know that these reports then last for 5 years and have to be done again 5 years later. But is there a time period that is required to actually fix the faults that you're talking about?
28 days.
28 days.
28 days. That's the time period they're saying you should have to fix it. They are saying that there's leeway on that, as long as you can prove that you've made an attempt to get somebody to fix it.
Right.
So if you email an electrician or text an electrician and say, please, can you give me a quote for this? They come back with a quote and you say, yeah, that's fine. Can you go ahead and do it? But they haven't done it for, 3 or 4 weeks. Then you can say, well, I asked him to do it and it's not been done, so you'll get a bit of a grace from that, because at least you've made an effort to do it. Now that'll only last for so long, because obviously you can't leave it for 6 months and then say, well, I told him to do it and that was that, because ultimately it's up to you to get it done. So, whether you go back to that electrician or you have a new electrician quote for you, whatever, but as long as you can be seen to be, taking it forward to get the faults fixed, and there is
some leeway as far as that's
leeway on that.
And so if you've given me the report, which of course I can see that you've done a number of these for me, which is absolutely great. And if within that 28-day period or whatever, I say, look, David, we make all the proper arrangements and everything else, and you go back and fix what needs fixing. Can I rent that property out in the meantime? This is a question from Sue that's come up in the chat box.
Can you rent it out in the meantime? Well, if it was an empty property, then no. You should have what we call a clean report. Now, there's two, as far as I'm aware, there's 2 ways that you can read into this. If you go to a letting agent, they want what's called a clean report. So they just want a report that's got nothing worse than a C3 fault on it, which is minor things, and they don't really come into not being able to let out the property. So there'll be really minor things. It might be that the fuse board's marked up wrong or something like that. Nothing that's going to affect anything electrically, but really minor things that yes, you should look at in future, but not urgent. If they've got those on it, then fine, you can carry on. If they've got a C2, which is something that potentially be dangerous, or a C1, then they have to be fixed before the new tenant comes in. So whatever period that is, you've got to have this clean report. Now, a letting agent will say, okay, you've given me a report, it's got, let's say, 1 or 2 C2s on it. I need them fixed before I let the new tenant in. Okay, fine. So you do the remedial work, and it's fine. Now, a letting agent will request that you then give them a new report that's obviously no longer got the C2s on it.
Okay.
Which to me is a bit backward, a bit, you know, whatever. But the actual letter of the law, if you actually look on the government website, doesn't say that. It just says you've got to prove that you've had the works done to make the report reasonable. Yeah. So you would need an invoice, let's say, from an electrician to say work done at this property was ABC and it's to fix these C2 faults.
Absolutely, which is a much better audit trail, really. Generally, it says this was wrong and now it's fixed, which is better information than not knowing it was wrong in the first place.
Yeah, and if you actually read the website, the government website, that is actually what it says. You know, it does say that you've just got to prove that you've had the work done.
And that follows the general health and safety risk assessment principle. Really, you're much better off with a risk assessment that actually shows risk that has been addressed, rather than a risk assessment that is completely clean as far as that's concerned.
Yeah.
So that's great, David. That's really informative. So I've got a couple of questions that come through. Joanna, what's the cost of doing electrical certificate for a buy-to-let? So let's say I don't know, a 3-bedroom semi in your company. Can you please advise what kind of fuse box needs to be in a BTR property? That's I see this question a lot, actually. So 2 questions there. Roughly, what is the cost, David? And let's just assume this is the basic 20% of inspection. But there's this question that comes up again and again where people are saying that if there's a plastic fuse box, you have to change it for a metal one. So I don't know if you can address that for us and clear that up.
Right. Right. Now, first of all, the cost. If you've got a standard 3-bed semi, let's say, generally the cost will be about £145.
Yeah.
And you know, people will say that's expensive, but you are there for quite a few hours doing this because obviously you've got to test each circuit, you've got to go into each circuit, so it does take time.
And unlike the gas, you're only going to do that once every 5 years rather than once a year.
Exactly. So people say, oh, it's more expensive than the gas, but it's not. Yeah. You take it over 5 years, it's a lot cheaper. So, you know, it's one of them. But that's the rough cost. And obviously, generally, the bigger the house, the more circuits are in it. So the cost will go up. It won't go up massively. You're probably going up to 165 for a, you know, sort of a decent sized 4-bed house and 175 for a 5-bed house. That kind of area. I mean, I do 1 2-bedroom flats for 125, you know, because generally you've only got 4 or 5 circuits in them, so it's a lot less than a house. So they're the kind of costs we're talking about. The fuse boards, right? Okay. The 18th edition regulations have stated that you've got to have a metal fuse board. They've got to have RCDs in them. And these SPDs, if you want them, you don't have to have them. But and then people say, well, if I haven't got that fuse board, then I'm not complying with the regs, so it has to be changed. But that's not the case, because what you're reporting on is when that installation was put in, was it correct and is it safe? Okay, so there will be things, I mean, these days, everything is this RCD protection. But when that fuse board was put in, it didn't have RCD, or it only had half of the circuits covered with RCDs, is what they used to do. It's not a fail because it's plastic and it hasn't got full RCD protection, as long as the tests carried out come into the regs. So it's got a good earth, it's we call it loop impedance, it's all the earthing arrangements, and to make sure that if you have a fault, everything trips out in time when it should do, then it won't be failed. It'll be a recommendation to get the fuse board updated. It will be a C3, but if there's nothing wrong with that fuse board and it's doing the job it was designed to do, then it won't be a C2 or a C1, it will be a C3, just to say, I would recommend that you get it upgraded to a new fuse board, but you don't have to.
No, that's great.
And to be fair, that goes for everything in the house. You know, you might have some old isolators or fixed equipment or whatever, it might be really, really old, but as long as they're safe and doing the job they're designed to do, there's not a problem.
Okay. And Joanne's asked another question, which I think we have covered again with regard to, she says, I've got a long-term tenant in my buy-to-let since 2018. I have time until the April 21 to have the EICR done. So yes, as long as the tenant doesn't change, Joanne, then that's absolutely fine from 2018. I think there's been a little bit of confusion around, it's almost a technicality really, that if you had a 6-month AST or a 12-month AST coming to an end in between June of 2020 and April of 21, then that could be technically a change of tenancy, in which case that's why I say even without the change of the individual tenant, the physical change of the tenant, it is actually legally a change of tenancy. But there's a technicality to that. It really depends on how the tenancy agreement is actually written as to whether that is the case or not. So I wouldn't worry too much about that, but certainly in your case, Joanne, you've got until April 21. Clearly the sooner the better, but that's that. So Dave, tell us with your own experience, what are you finding out there from doing these inspections?
Various things. Most things are the best properties are the ones where people say, oh, I don't like electrics, I'll never touch them. Now they're brilliant for me because the chances are an electrician installed it, and so when it was put in, whether it was 10 years ago or 60 years ago, it was put in by an electrician and it was right at the time. And when electricians put things in, there's a sort of a logic to it. So it's easily, you can easily trace through it and you can easily see what they've done, why they've done it. So it's better. When people have been, Mr. DIY, 20 years ago had a crack at it, that's when things become a bit more interesting. And you do see various things. A common one that happens a lot is ring mains. So for your sockets, you have a ring main. Now, by definition, it's a ring. So the cable basically comes out of the circuit breaker, goes to the first socket, the second socket, third socket, however many, and then comes back to the breaker. Thereby, it's a ring. Now, quite often, I am finding that there's a break in the ring. So all three of those conductors, the live, neutral, and earth, should all be all have a resistance at the end of them. You should be able to say, okay, that's fine. There is a resistance. A lot of the time, there isn't. So there's a break in the ring. Now, everything's working, and I won't bore you with the technical details why, but everything's working. But in effect, what you've done is taken a whole ring and made it into two halves. And then the circuit breaker protecting them is too big for the cable that's now in two halves. So that can be quite a dangerous situation to be in. And that is something that on the report you would put a C2 and it would be an F1. The F1 is further investigation required. So the C2 part of it is it's potentially dangerous, and then the F1 is further investigation is required to sort of, because it's not something you can say, yes, that needs to be changed, or whatever. It's something obvious like a light fitting or a socket front or something like that, which you might say is damaged or missing or whatever, then that's fine. But in this case, it's something that's not tangible, you can't see it, so you would have to investigate further, go into that to find it.
That's really interesting. I'm going to bring Sue into the room, David, because she's asked some questions in the chat, but I'd rather, Sue, I'd rather not try and translate your question, to be honest.
Well, the first one was, if we get round to next April and I wheel in my assessor because it was an existing tenancy, and it fails, do I still have the 28 days, or am I suddenly in breach of the tenancy, or do you not know the implications?
As far as I'm aware, you will have 28 days to sort it out. So even if you got somebody, an electrician in there on March the 30th, then you would have 28 days from when that is when the EICR is issued. So as far as I'm aware, that's right.
And I would need a retest in order to be, so it's a bit like an MOT. I have to go away and get the job done and bring the car back and have a clean test to be legal.
No, well, this is what we're saying. You see, now in the government website, and you can look yourselves, it just says that you have to prove that you've had the work done to rectify in effect the bad faults. So as long as you've got your original certificate, and then with it you've got an invoice from an electrician to say that those faults in that report were fixed, then that really should be enough to say, yes, there we are, it's done. The faults are fixed on that report, and there we are. We're happy.
This is not attacking you, but it won't do for possession though, because I don't have an EICR that has passed.
No, but you've proven that the failure on the EICR has been rectified.
Yeah, but I think it's
to be fair,
form. Yeah,
it is a bit of a grey area, but there is, I'll actually try and read.
It's not your fault.
Yeah, well, there are grey areas in it, and everybody's reading of the the new legislation can be different, as they are with the regulations. You can read things in a different way. You go to a letting agent, yes, they want a clean report no matter what, and that's it. I'm just trying to find what it actually says on that.
While you're looking, David, I imagine.
Carry on.
I imagine, Sue, that if this had been in July of 2020, the judge might take a different view than in April, May of 21, when they said, well, you've had a sufficient.
Right, here we go. Yeah, so on the gov.uk website, there's a section that says remedial work. So if the report shows that remedial work or further investigation is required, as set out above, landlords must complete this work within 28 days or any shorter period, if specified as necessary in the report. Landlords must then provide written confirmation that the work has been carried out to their tenant and to the local authority within 28 days. So it doesn't say you have to get a new report, it says you have to have written confirmation that the fault has been fixed.
Okay, thank you.
That's on the government website.
And have you had your property in Retford done yet, Sue?
It's because it's an HMO. I'm still in the 10 years of or 5 years, sorry, of the original thing. So no.
That's interesting. That prompts another question for you, David. That 5 years ago, Sue had a assumingly clean report, or if there was anything needed done, has been done. If she has done nothing in that 5-year period to the electrics, what's the likelihood of her having a clean report this time around? Has the premises changed at all?
Haven't done any connections or anything in that time.
Yeah.
The likelihood would be very high that it would pass them, because unless something's been damaged by the people living there, because obviously if you've got a socket front or a light switch or something like that that's been smashed or cracked, then obviously that could be dangerous. But assuming that nothing untoward has gone on, then really the likelihood of it passing is very high, I would have thought.
Right. Yeah. So there's a similar question to ask the next chap about EPC, because often it's a case that the goalposts change over time. That a report done 5 years ago, that they might be more stringent today than they were then in that regard.
Yeah, but what I'm interested in is the retrospective problem. Let's say I have got a plastic fuse box, right?
Yeah.
Which is not to the 18th, whatever it is, 18th edition, and it would have been a failure if it were tested 3 months, 6 months, 9 months ago, but it wasn't tested because it didn't have to be tested. and I get it tested in March next year, can the tenant then say, actually, well, the bloody place wasn't safe when I moved in September, and you must have known it because
Right.
nothing's changed?
Right. The only time that would be a problem is if that fuse board, the 18th edition came in 1st of July last year. I think it was the legal requirement for the 18th edition to be followed. So if that fuse board was put in before the 1st of July last year, then no. The fact it's a plastic fuse board, it was right at the time of installation, because at the time of installation, you couldn't really get metal fuse boards. You could only get the plastic ones. So if it's been installed after July the 1st and some electrician has just put an old plastic fuse board in that he had lying around and he wanted to get rid of it, then yes, it's a problem. Because when it was installed, and if you've got proof that it was installed at whatever time, then it's a problem, because from the 1st of July, it should have been a metal fuse board with all the appropriate bits on it.
The wrong example.
If it was installed before that.
Well, I've got one with the domino fuses.
Right, okay. Now, the problem with them, there can be a problem with them because the tripping times can not be fast enough. So there can be a problem with them. Not 100%, it depends on each property, to be fair. But because they are so old, the old semi-rewirable fuses, they are, they sometimes don't fall into the tripping times. And that can be a problem. So it's not necessarily, it would definitely fail, but you're more likely to have a problem with those.
Yeah, you know what I mean? What I'm saying is that it's getting very difficult for landlords to evict tenants, and if there is a fault with the property, it is even more difficult for landlords to evict tenants. And this is the first time when we've had a combo of problem to evict tenants and new legislation. And I have a feeling that savvy tenants are going to start using electrical arguments against it being an unfit, you know what I mean? They're going to say it was an unfit property and nobody told us. When we moved in, let's say sometime in this window between the 1st of July, they were already in, weren't they, before the regulations changed, so that it's an existing tenancy.
I think what it boils down to the landlords, and like yourself, would be is you don't know what the electrical bits and bobs are. You don't know. You're not trained in electrical anything, so you don't know. Yeah. So you're hiring an electrician to do that job for you. So you are taking reasonable steps to make sure that everything is in place for your tenancy. So if anything did come back to you, and government or whoever said, well, what did you do to make sure anything was in place? You have hired a competent person, electrician, to carry out that inspection for you. If there's something wrong with it, the problem lies with him, not with you. So, you know what I mean? It'd be. I don't think you'd have a problem evicting a tenant because of it, because you've done everything that's reasonably practicable, as I say, to make sure everything's in place and done right.
Right, thank you. Yes, I get it. Okay, thanks.
So we've got a question with Joanna. I'm not sure she's going to unmute herself to ask it herself. I think there may be an issue here with regard to the difference between an EICR and portable appliance testing, actually, which says, what's your advice regarding electrical appliances, cooker, fridge, etc.? Is it better to buy them before or let tenant to bring them in before EICR is done, or you don't check them when you do the report?
Yeah, that's getting confused. PAT testing and the EICRs are two completely different things. So EICRs are for the fixed wiring in the property. So that's your lights, your sockets, your cooker isolator, anything like that is fixed wiring. Anything that's got a plug on it is portable, and that would fall under PAT testing, portable appliance testing. Now, portable appliance testing, again, isn't a legal requirement, but anything that's over a year old, you should get done once a year. So if you've left a fridge in a property or a washing machine in a property, things like that, yeah, by the letter of the law, in a way, you should get that tested every year to make sure that it's satisfactory. Again, that's not a legal requirement, and I would go back to what I said earlier about it probably falling under a duty of care. So if I was, well, I am a landlord, I would leave as few things in the property as possible.
Yeah. And what about the cooker? Because of course that's neither, is it? I mean, that's not a portable appliance because it's hardwired in, but it's not part of the circuitry.
Depends on the cooker, because some cookers are plug-in. So yeah, those come under pat testing. It's a plug-in cooker. If they're hardwired in, then the test will test up to the isolator. You can test so far to the cooker, but there is one test we do that you wouldn't go to the cooker because it can damage it. But all the other tests you can do to the cooker itself.
So does the cooker fall between the gaps then? I mean, if there was a problem with the cooker that nobody knew about, would it not get picked up because it doesn't fall under portable appliance testing or EICR?
Well, you're testing the cabling up to the cooker.
Right.
So as long as that cabling is right, and as long as all the tests pass, if there was a problem with the cooker, you'd like to think that the fuses will trip out before it went any further. And that's the whole point of this, is you're making sure all your tripping times, all your RCD times, all that kind of stuff is correct. So if there is a fault, things trip out. You know, your fuses trip, and that's a lot of what we do. The testing we do, I'd say 80+% of it is to make sure that things trip out when there is a fault. That's brilliant.
Any other questions for David? Because this has been quite an eye-opener for me. This is some great information so far.
I will say one thing is that they're very serious about this, because if you don't get the report done in 28 days, and I only read this, I didn't realise how big the fine was. If they want to fine you for not doing it or not making an effort to do it, they're saying the fine can be up to £30,000, which, wow, you know, that's that's a serious.
So who's the authority that would be doing that then, David? Do you know?
As far as I'm aware, it's the local councils.
Right.
So okay, at any time, if you're a landlord, at any time a local council can ask you for your EICR.
Okay. Yeah, so if you pull a class one over your council or want a planning application against them or whatever, and
anything like that, yeah, they'll start looking at things. You know what they're like. Your little pile of paperwork, you're at the bottom, but when things happen, you soon go to the top, and then you're looked at. And if you've not got everything in place, that's when questions start getting asked.
Okay, so there's that, and of course, the other issue which Sue has been focusing on mostly as well is this issue of tenancy and evictions of tenants, which is, you know, making sure that you've got all the compliance documentation in place before that. That's fabulous, David, and thanks for giving us all your time on that. I've popped your phone number into the chat if anybody's interested. If you want to add anything there, David, if you want to add a website or email address or whatever, then please do. And people can use that for future reference, particularly if they're in the East Midlands at least, and are looking for somebody to do their testing for them. Brilliant. So we're coming on, it's 22 now, and I noticed that we've got Gareth in the room. Gareth, thanks so much for joining us. I'm just going to unmute you now and just do a bit of housekeeping of the screen, and then we'll kick off talking about EPCs. So just one moment. So, following on from that really interesting Q&A session that we've just had with David on the EICRs, we now come on to talk about EPC, something that perhaps we've lived with for a lot longer and understand a bit more, but particularly what we're interested in as well is what's upcoming, what grants may be available, what is the direction of travel really with regard to energy efficiency going forward. So I'm really pleased to welcome Gareth Clarke. Hi Gareth, can you hear me okay?
I can, loud and clear.
Brilliant, fantastic. And yeah, Gareth, would you like to just introduce yourself and your company and what you do, and then we can kick off with some questions.
Yeah, absolutely. I don't know whether or not everybody can see me or not. I don't know whether or not my hands are showing on everybody else's screen, but yeah, first of all, thanks ever so much for inviting me on to this and giving me the opportunity to talk about the energy surveys. Talk Green as a business is something that I set up in 2006. So right at the start of the introduction of the legislation, and we've pretty much moved through that industry since it was originally conceived or inception. We do everything from residential through to commercial through to public buildings in terms of energy surveys, but we nowadays do a significant amount of sort of carbon-based surveys, but also, and more importantly in the residential sector, is something called pre and post analysis. Where we might go to a property, it gets a G or an F category. Everybody should know the problems with that. And then what we will then do is we'll guide landlords or estate agents, letting agents down the route of what they can do in order to ensure that the property achieves either an E, a D or a C category. We cover predominantly residentially East and West Midlands, but we operate throughout the whole of the country. On the commercial side and with things like the drone, where we do sort of thermal imaging as well. So that's the nuts and bolts of the business, although in my head it seems a lot bigger.
I didn't expect you to be bringing any props into this, so that's really interesting, and no doubt we'll have some questions about that later. So yeah, I mean, EPC, the one question that came up, I think initially, which maybe thought would be really good to bring you in and talk to you about it. EPCs last for 10 years, so we've been talking about gas certificates earlier lasting 1 year. We're now talking about electrical certificates, which are 5, but EPCs are 10. And many of us as landlords are going through a process where we're having a look at our EPC and saying, oh, it's coming to the end of its 10-year period now. We've got to get somebody in to actually do another EPC test. But of course, what we've got is potentially properties which might be currently an E. We know we can't rent them out if they become an F. And we haven't actually done anything to the property since we've owned it. So has there been any changes or any change in stringency, I would say, which could put us at risk here, where we may not maintain that class of being an E?
Yeah, absolutely. So that in the last 14 years, we've seen some significant changes in all of the calculation and the methodology that sits behind the energy surveys. And without blinding everybody with science, the easiest way for me to explain it is, for argument's sake, if you'd have bought a Toyota Prius in 2010, that car would have been probably one of the most efficient cars on the market. However, if you buy a brand new Toyota Prius today, it's not going to be anywhere as, the one that was bought 10 years ago will be nowhere near as efficient as the one that was purchased today. So what happens is that the efficiency of things like boilers, even building fabric, is adjusted over periods of time, which if you had an EPC redone that was done 10 years ago and exactly data was used, we'd probably find that the EPC rating would have got worse.
Okay, so that's quite a concern, obviously, to people who are currently sitting with an E from that point of view. What would you say are if you like, the priority of areas that they might wish to be looking at in terms of improving? considering cost as well as obviously the gain that different things can make.
Yeah, okay. So in terms of sort of like the quick fixes, there are a couple of really straightforward ones. So I'll just start off by saying that F and G category properties they're not commonplace. We tend to find that a property that achieves either an F or a G category has purely electricity heating, so storage heaters or room heaters, or potentially somebody's spent a fortune and installed some really fancy looking electric heaters and they're still terribly inefficient. But if you've got a property, for argument's sake, that's got no loft insulation, it can be done. It's very simple, very straightforward. You take a property that's got, say, 25 mil of loft insulation, increase that to 300 mil. It will probably make a 5, maybe 6 point difference on the energy rating. If you've got things like a cylinder tank that's not got a thermostat on it, it can make a 2 point difference. And installing the cylinder thermostat, they're £27 from Screwfix, and then whatever the cost is of the electrician to come along and fit it. So again, it's when we're talking margins in terms of just trying to get into an E category or keep it in an E category, there are simple things like that that can be done. In the same way, if you've not got TRVs on radiators, or you've not got a programmer or a room thermostat for the central heating system, again, they're inexpensive, but will be enough to ensure that the property is falling into the right category. I think one of them, sorry, go on.
Sorry, I'm trying to get a feel here, Gareth, about what a 2 point or 5 point difference makes. Is there a fixed number of points between each letter?
There is not a fixed number of points between each letter. It's graded. So 1 is the worst and 100 is the best.
Right.
And in all of my 14 years of surveying, I think I've probably 100 is an A category and 1 is a G rating.
Right.
So if you base it on that scale, and in all of my 14 years, I've probably had about 3 properties that have fallen into an A category. The Nottingham Ice Arena is one that we've done regularly. That always gets an A rating. So it's that when I say in terms of on a points difference, the reality of it is that 1 point can make a difference between an E or a D category, or an F and an E rating. It's the argument that it rains somewhere and it stops and then it starts somewhere. The point is that, it's every single point can potentially get us into the next category. And that's where sort of our pre and post analysis service comes into its own, because we can look at batching things and say, well, if you do this and this, it will achieve a E category. If you do this, this and this, it will take it into a D, and so on and so forth. So yeah, to answer that,
it depends where you're starting from. If you're the top end of an E and just below a D, then you might have to do very little. But if you're at the bottom end of that E, then more needs to be done.
Yes, yeah.
And interesting, you said that the Nottingham Ice Rink was an A category. I suppose they had a commercial reason for being one in the first place.
Well, it's slightly different, and to be fair, that's probably not a very good example to use, only because of the fact that the way in which the the public building energy surveys are built is it looks at the fabric of the building, but it also looks at how they use the energy within the building and recycle and reuse and renew, i.e. through renewable technologies.
Right. Okay, no, that's very interesting. So I'm going to bring Carol in because Carol's got a question and she's much better at asking it herself than me. So, hi, Carol.
One of my favourite topics.
Brilliant.
Because I loathe the bloody things. Because I've had so many problems with them. I had a flat that was a new conversion from when it offers to Resi, and I had to fight once I'd realised that he hadn't actually realised that it had been modernised and brought up to building regs. So I had a really downgraded one.
Yeah.
I've got another one. It's a scheme. Oh, sorry.
There she is. Welcome.
Sorry, I thought I clicked both of them. I must have double-clicked the one. I've got one flat in a scheme, identical flats, ground floor, 1 beds, all electric. And when I looked at the same time as I realised this problem, the EPCs ranged from 44 to 68.
All on the ground floor?
All on the ground floor, all identical positions, identical floor space and everything.
So no increase in terms of heat loss parameters in external wall area?
No.
Yeah, it's a challenge. Sorry, go on.
It annoys me to beep, 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 beep.
Yeah.
Because they're just, it was brought about as it meant to give you a good guide on the property, but it just seems that they're so poorly done, not an insult on you, but
No, I understand.
If it's not providing the same value between like for like flats, then to me it loses its relevance. And I'll agree with your comment about, because I've had two done. I had two properties that were both C's. So one was 70 and one was 78. And I had them redone last year. And I'd spent money, I've modernised the heating. On the one's electric in a modern flat. The other one, I'd put double glazing in, I'd insulated. I'd put new boiler in, thermostats, low heating. And both of them have gone down to D, and the one is literally just a D. And it causes me great concern. There's all this talk about, oh, we must go forward. We've got to get them all down to D by, is it 2025 or 2030? How is it ever going to be achievable? And how realistic are they? I mean, what research do they do to actually make sure that they're providing useful information? Because it almost seems like they're the be-all and end-all of how we're going to meet all our climate requirements. But to my mind, I have serious doubts about them.
Yeah, okay, well, I understand that, and I take on board everything that you've said there, and there's some really key and really interesting comments that you make as well. I think if I try and pick them apart, and what I mean by that is try and look at every element that you've raised. The first one is that if you converted a commercial property to a residential, you shouldn't have had a standard RD SAP EPC completed on that. You should have had SAP counts, which is full-blown SAP counts that should have been done on that, because it's a conversion from a commercial to a residential dwelling. But if that went through building control, which it often does, I'll say, it's a lot cheaper, then that's fine. The other thing with that is that...
Well, I actually bought it before it was a requirement. So when the requirement came in, I got the agent to get somebody in to do the EPC.
Okay.
And it was the person they brought in that hadn't realised. And I had to go back to them and chase them. Luckily, they were still doing it, so they were able to update it. Because if they're not still doing it, you're stuffed.
Yeah, well, no, not necessarily, because, you know, once an EPC or report is lodged, if somebody comes back to us and says and challenges it, so as a company, we probably do somewhere in the region of 150 to 200 surveys a week, even at the moment. Yeah. And, you know, we've got sort of 7 assessors that are out there doing the surveys. They're all very well experienced. They've all been what we would consider to be professionally trained. And I've spent probably 2 weeks with every single one of them as they come into the company. And, you know, consistency is something that we try and make sure that flows through our organisation completely. The reality of it is that as humans, now and again, we all make mistakes, and we're not insulated from that either. So for argument's sake, if I went out and did an energy survey and I put down that the property just had a Worcester Green style boiler, but I didn't put down that it had got a room thermostat program and a TRV, that can be rectified. I can go back, I can re-lodge that EPC and cancel the existing one. So there are ways in which it can be dealt with. But with our admin team, one of the most important things that we deal with is we talk to people. So when we're booking surveys, and it's not just, you know, name, rank and number, we'll see you on Tuesday. You know, we ask them about the property. We look at the EPC data, if there is any, from the existing or an expired or a current EPC, because that serves a lot of purposes. And that enables us to understand how long we need to put a surveyor on site for, because if it's a mid-floor flat that's 54 square metres in comparison to a 5-bedroomed property that's 280 square metres, There's a big difference in terms of time allocation. But what we'll also ask of them at the same time is things like loft or buildings in the extension. So if somebody's had an extension to a property, great. We need to see building regulations. Attic rooms or loft conversions are an absolute nightmare in our industry to deal with. And the reason for that, and this covers quite a lot, but the reason for that is because if we go to a property and we can't evidence the insulation, we are not permitted to factor it into the reports. So for example, if somebody says to me, we've insulated the whole of our ground floor, because we've got a timber floor, we took all the floors up and we've insulated it, and then we put the floors back down. Our first question will be, have you got photographs? They'll say, no. We can't then factor that in. Now we have that probably 3 times a week. Somebody said, well, I'll take a floorboard up. The problem with that is that it's not enough, because if they take a floorboard up and we see insulation, there's nothing to say that the other 90% of that floor isn't insulated. It's not that we don't.
Would an invoice for getting a contractor in to do it cover it?
It would in my eyes, and from our perspective as a company, I would stand behind and support that. And what I mean by that is that our auditing body would say it's not enough, whereas I would stand there and go, 14 years experience, there's enough evidence there, as far as I'm concerned, from our professional indemnity and public liability insurance, professional indemnity insurance to cover that. So we would take it on the basis of the fact that that floor was insulated. But this is the other thing, is that what most people don't understand or see is that behind us we do have 6 auditing bodies that will come along and they'll audit every single assessor individually on approximately 5% of the surveys that they create on a monthly basis, and they'll check those. And if we can't prove or evidence certain elements, they will fail the audit and they'll tell us to rectify it, relodge it, and cancel the old one. But if the assessor, so it's not the company, if one of our 7 assessors did that, I think it's 3 times, they get suspended. They then have to do remedial action to unsuspend themselves. If it then happens again, they then are at risk of being expelled from the scheme. So on that basis, they are potentially at risk of losing their livelihood, because we employ them as energy assessors. And if they're not an energy assessor, because they've been expelled from the scheme, unfortunately, they've lost their job and their livelihood. So that's something that's, unfortunately, that's only come about in the last 3 years. And I say unfortunately, for many reasons, but the main one being that it should have happened 14 years ago. And if it had happened 14 years ago, with the potential risk of the expulsion, it would have kept the industry as professional as we'd have liked it to have been. But coming back to one word that I did say, and I'll hang my hat on a little bit, is consistency. It is very difficult to get consistency within the EPC market amongst different companies. And, you know,
it's not helped either that the information that was lodged when it was done the first time isn't available. When you come to do a renewal, you've got to start from scratch.
It is. We've got access to quite a lot of information. So like I say, if somebody calls up, if an agent...
The reason I say that is that I was getting one done for a friend, and he was having to enter it all from scratch, and he said to me, oh, it's a shame that we don't inherit the data, we've got to do it all from scratch. So it's interesting you're saying that. That's a learning point.
Yeah, I think that just to clarify on that point is that there is a lot of data on the EPC register, which has just changed on Monday, I might hasten to add. But there's a lot of data on there. So there's not the actual minutiae of detail in terms of the heat loss perimeter or the party wall length, but there's a lot of information that we can obtain from an EPC to utilise, to check, to clarify moving forward. So, but it's not the nuts and bolts of the energy survey. But I could, if you gave me an energy survey and said to me, what do you think is in that property? I'd probably be able to tell you the type and style and the age of the boiler, the controls. I'd be able to tell you the heat loss perimeter. and party wall length, but that's just purely because of experience. That's all that is. But if I come back to the word consistency, the difficulty that we've got is that, and the industry as well, the industry has been a challenge, especially in the last 8 years. And I don't know how many people are sitting listening to me. I hope you're all still awake, but probably not. But the Green Deal that launched in 2012, I think it was one of the worst things that could have happened to this industry. Because what happened when the Green Deal was launched, it was all based on carbon. So you would get funding based on how much carbon was going to be saved by introducing X, Y, or Z measures. What happened was companies like Mark Group, which have since gone into administration, they employed their own Green Deal energy assessors and made sure that all of their energy assessors went out and made the properties as bad as they could be. So they would go to a property and maybe they were installing cavity wall insulation, and the property might have had a really fancy boiler in there, new one, with lots of loft insulation. They'd go along, they'd do the survey, they'd put it down that it had got a poor boiler, no loft insulation, because the carbon saving would have been that much instead of that much. So Mark Group got that much money instead of that much money by utilising their own employees to do it. And I was fortunate enough to sit on a couple of the steering committees for Department for Energy and Climate Control. I told them that the whole thing would be rife with fraud, and it was. They did nothing about it. And I gave them numerous cases before I gave up. But
that explains my one where it was cavity wall insulated. Actually ended up with a lower EPC than it had before.
Yeah.
And I understand the owner of Mark Group sold out about, what, 9 months beforehand?
Yes, that's right.
Yeah, I met him. Sue's got a quick question, so I'm just going to bring Sue in, and then we can move on and talk a bit about potentially about grants in the future, perhaps, Gareth.
Yeah, that's fine.
Hi, Gareth. Very interesting. Increasingly, as property professionals, we're sent to the EPC to see the size of a property that we're looking at. And I've had a first-hand experience of this in that I own a 3-bedroom flat in a development where only 6 of them are larger than the other 30. The EPCs for my block have size of 74 square meters for the 3 beds, which are actually 119 square meters border to border, and they show 93 for the 2 beds, which are about 930, you know, about right.
Yeah.
You said that you never inherit any information, and there are 3 flats stacked on top of each other, all of which are exactly the same size. They have EPCs done at different times by different assessors, and they all say 74 square meters. Are they picking that up off the valuation office or something?
No, highly unlikely. How old is the property?
1968.
Oh, okay. No, I mean, you know, we will use the square meterage that is available on the EPC register from the existing or the lodged EPCs, whether they are valid or expired, only purely from our perspective, so that we know, so that we know how much time we need to allocate to a specific assessor at that property. But I just say that potentially, were they all done by different assessors?
Different people over different years. Yeah, and it presumably some Burke made a mistake and everybody's copied him ever since, I guess.
Well, maybe they just looked at the previous EPC or the next door one.
That's what I'm saying, Rupert, and the first one was wrong.
Yeah.
Yeah, it's very difficult to answer that, and the reason why I say that is because I'm really confused. Because if somebody's physically going to site, which they should be, because you can't do an EPC without visiting the property, the time it would take to measure a property from left to right and front to back would take seconds.
Yeah, and particularly because it's actually a rectangle footprint.
Yeah. Yes. So, you know, I don't know whether or not somebody's, or I'll say somebody, some three have obviously got the measurements all mixed up and wrong. But, you know, every property that we go to is measured within an inch of its life.
Well, I can't assume that there was a sort of valuation office size or something that, you know, it's a bit like booking, you know, registering something onto Amazon. They've got it on their system.
Yeah.
You know what I mean?
Yeah, I do. Yeah.
It was one of those.
Yeah, no, there is not for residential. There is on commercial. So when we're pricing up to do commercial energy surveys, most people that have got commercial buildings have got absolutely no idea what the size of their units are. Mm. So we use the VOA to go on and look at the size of the premises so that we can obviously price accordingly.
Okay, so I just follow my bloke. I need one coming up at the next tenant change because, you know, I've owned it for 10 years. Since it was originally done. I never noticed mine was wrong. I never thought to look.
Yeah, I mean, it's, you know,
this time.
It's quite, is it Sue, did you say?
Yeah, it's 13 years now, but I haven't had a change of tenancy since the 10-year mark. Okay.
Yeah, now what I was going to say, Sue, is it's quite interesting that you're actually paying attention to the square meterage of the property, but also you referenced and you mentioned about potentially investors looking at an energy survey, and you know their decision may be influenced by the size of the property, and if it's detailed on the energy survey, that might be an influencing factor in terms of whether they buy the property or not. I'm sure it wouldn't be the main one.
We taught, Gareth, as a method of remotely valuing a property, particularly in London, where there are often different sizes in the same block and you can't get in to look. And you just pick up the EPC and assess it based on, you know, some others somehow.
It's definitely the first port of call for any desktop assessment. Just go to the EPC to look at the square meterage. Yeah, and then a quick calculation for your price per square meter and everything else. So, it is influential in that regard.
And it's something that should be done. It's something that people should be looking at, not because it's what we do or our industry, but it's so important. But what we tend to find as well is, and I can't emphasize this enough, if you've got an energy survey that's especially sort of been produced around the Green Deal time, so 2000, I think it was 2012 through to about 2006, the inaccuracy in the energy surveys within that period are so vastly incorrect in the main. And it's really important to get them right. We have investors that contact us that we deal with regularly, and they'll look at a property, and I can give you an example of one that was purchased in Carlton probably about 11 weeks ago. It was on the market with an estate agent. It had got an F category. They were really keen on buying the property, but didn't want to because they knew that if they bought it, they couldn't rent it. So they said, can we go back out, check to make sure that it's right based on what's there, this, that, and the other. We went out, it was a D category. They bought the property because it was a D rating. The person selling the property secured a sale because of that. The investor secured the income moving forward because they spent a little bit more money to get an energy survey that was correct and that was up to date. We are constantly telling estate agents to make sure that the energy survey is representative of the property today, to ensure that they're doing everything that they can for the property seller to make sure that every opportunity is available and open.
That's interesting, Gareth, because I put a property on the market recently, and the agent decided to send their photographer around, which I had some pretty good photos, professional photos already there, so I was a bit surprised, but he had his particular way he wanted to do it. And along came an EPC assessor with the photographer, and I had no idea, but he just wanted to make sure that that EPC was up to date, and even though it was within so some people are listening to you. Some of the agents are listening to you.
Good.
Yeah. But I've got a question, and I'm conscious of time as well, and I'd like you to tell us a little bit about the future. But before we go there, how do you know what type of construction is the building? If it's a non-standard brackets, i.e. not brick and stone construction, do you know exactly what kind of non-standard construction it is? And that's from Joanne.
Okay, so Joanne, to answer your question, in terms of the energy survey, it is quite rigid, but when we look at wall construction, it's either park home, solid wall, cavity, timber frame, or system built. System built is a bit all encompassing. So it could be that it's a concrete precast stone, like a Wimpy's no fines construction. And it could be a non-traditional type of construction. But what will also apply in that respect is that the assessor or the system, the software, will ask for the age of the construction of the property. So if you put down that it's, say, a 1960s property, and then you put down that it's system built, it's going to be terribly inefficient. That doesn't mean to say that it can't be made to be efficient. But that's the only way that I can probably explain that is that system built is sort of a non-traditional, even prefab type properties where the corrugated steel or just block work. There's a lot of those in a place, I don't know whether or not it was local, but Clifton. Clifton was one of the largest prefab built communities, forgot the name, but communities after the war, as was Newark. Newark is full of properties that are Wimpy's no fines, precast concrete stone, and they are 350 mil wide in terms of the wall thickness, and they are horrific.
We have a national audience here, although we do have a bit of an East Midlands bias, perhaps, or say Midlands bias, really. What sort of reach do you have with your services, Gareth?
Well, we cover residentially. We are in the main everywhere from sort of all the way over to the east coast, so Sleaford, Skegness, all the way up to Grimsby, Sheffield, right across to all of the Dales in Derbyshire, all of Derbyshire, Leicestershire, and obviously Nottingham because that's where we're based, but all the way down as far as sort of like Wolverhampton, Kidderminster. But we have, because of how long we've been doing it, we have got a good network of external assessors that we can direct you toward. If you, for argument's sake, were in, say, Caerphilly or Kent, but we have done residential energy surveys. We do a lot of projects as well. So, we've been up to sort of like Newcastle and Blackpool and as far south as Hastings, I think.
Okay, so you're covering quite a few, and Sarah in the jeans in the photo behind me right now, she's from Kent as well. So you can be a first port of call as far as that's concerned. So let's talk a little bit about the future. At the moment, you need to be an E. Is there going to be a time when you need to be a D in order to rent your property out?
Yes, my first question is, how much time have we got?
Right. We have Stefan in the room at the moment, who's itching to talk to us about insurance at 2:30. But I'm sure that Stefan would be happy to, delay a few minutes, 15 minutes or so. So.
Okay. So in terms of the energy surveys, and this is something that I can't emphasise enough. If we look at the future, when we get people calling us and go, I need to get my property into an E rating because I can't rent it. Okay, well, that is true. It's correct. And it will be correct now, and it will be correct next year. But if we get that, the first thing that we ask people is, are you keeping the property for 5 or 10 years? Because the reality of it is that it's quite easy to get a property into an E category. But by 2025, if you want to rent a residential property or commercial, you will have to get that property into a D category. By 2030, same applies, but you will have to get that property into a C category. Now, don't get me wrong, you cannot get every single property into a C category easily. And in certain circumstances, and I'm dealing with one at the moment, I won't go into it in too much detail because I need more time, but in circumstances where you can't get them into a C category, what we will be able to do is apply for an exemption. And again, that's something that as a company that we've been doing for the last 2 years, I think it is since the MEES regulations came into play, where we can apply, because we've got direct claim status, for an exemption on a property based on all of the different elements being achieved. But what we say to clients is 2025 and 2030, if you're going to try and improve the efficiency of a property now, you might as well do it, and do it all now, because the cost-wise, proportionally, will be probably 40% less to get a property into a C category than it will be trying to achieve a D. And then in 5 years, trying to achieve a D. And then in 10 years, hoping to get it into a C. So, you know, we're looking at, we've got a certain client that's got around about 340 properties in the centre of Nottingham. They're all student accommodation. They are all solid wall. And in 10 years' time, he's not going to have a business because he's not going to be able to rent them. It's as simple as that. So what we're doing is we're going to each one of those properties and looking at every single element of the building to try and make it as efficient as possible. So insulating timber floors, we can cost it, we can tell you exactly what the rating will be afterwards. Internally wall insulating certain aspects, or if it's in a externally wall insulating aspects of the property. If it's in a conservation area, internally wall insulating it. Getting it so that the fabric of the building, and that's the walls, the floors and the roof, are as efficient as possible. And then he's going to go down the route of installing air source heat pumps at every single one of his properties. But we've told him not to do that for at least 6 years, because the cost of air source the cost of air source heat pumps in probably 5 to 7 years is going to fall through the floor. So that's what I mean when we do an energy survey, especially for landlords and that are conscious and that are focused and that are keen to move things forward. We don't just do an energy survey.
And that was crossing my mind, that I also understand that gas is on the out and won't be allowed in after 20 whenever. So,
yep.
And
that's
the two things come together there.
That's right, and that's why when we talk to people about, if you're building a brand new house and wanted to install air source, great, we can talk to you about that, and we can push you down the route, we can just encourage you to look at different elements. But the reality of it is, as far as I understand, that it's been passed in law now that from next year, I think it is, that new build developers cannot install gas into properties, and everything will be pushed down the electricity route. On that basis, it will all be air source. So of course, the reality with that is that the economies of scale will come into play.
Yeah. And
the cost of air source will fall through the floor. Mm-hmm. The second thing on that is that it will be incredibly difficult to influence or affect the retrofit industry or the existing build industry unless they kick landlords again, which I can guarantee, because I'm one of them as well, that's exactly what they'll do, because they're the first people that they kick. And it will be from a certain date, probably around about 2028, they will start to say to landlords, you've got to take out gas and put in electric. There'll be funding for it, potentially. But mark my words, it will happen.
Interesting. And so tell us a bit about funding. I believe it's not brilliant at the moment, but is there anything around the corner?
Yeah. For those that continue to watch the news, as fun and exciting as it is on a daily basis, Rishi Sunak announced, I think at the beginning of July, that we would see something called the Green Home Grant that was due to be launched at the beginning of September. That scheme launched at the beginning of September. Nothing's happened with it because none of the meat has been put on the bones. The nuts and bolts of it, the bare bones of it, is that it should be all finalised by the end of this month. But if it's not, don't come shouting to me. But the nuts and bolts of it are that you will be able to qualify for or claim up to £5,000 or 2/3, I think it is, of an insulative measure that's on a prescribed list that's introduced or installed at a property by a trust mark approved contractor.
Mhm.
Or in certain circumstances, you'll be able to claim £10,000 for occupants of properties that are on low income or are on certain benefits. However, I did get handed a document 2 days ago that said that they weren't sure whether or not that was going to apply in the rental sector.
Right.
So it's very difficult, but I'll always be honest, and that is that at the moment, until it's all been concreted in, we sort of go, it's there. Once it's confirmed, we then pick it up and move it forward. And you know, the only word of advice that I would give to any landlord at the moment is that you're going to have to utilise a trust mark approved contractor. You will need a retrofit assessor and a retrofit coordinator that will sign everything off. And getting any of those three at the moment is probably like finding hen's teeth. So start looking.
And are you one of these retrofit? Sorry.
Yeah, there are 20 retrofit coordinators in the country.
Right.
Unfortunately, I made the decision to get one of our most experienced assessors trained up at the beginning of July. And then on the retrofit assessors route, yes, we've got 3 of our assessors are retrofit assessors.
Okay. So we'll be leaning upon you once these regulations are set in stone to come back to us and tell us a little bit more about that, if that's all right. You know.
Yeah, absolutely. That's not a problem at all. But I think that one of the major issues is going to be getting the tradespeople to do the work because there's not enough of them. Right.
Okay. Now that's very interesting. So tell us a bit about that thing on your right then.
On my right. So that's the drone. Do you know what? I did that because I thought, well, when I see all these people that do these Zoom meetings, they have a lovely bookshelf behind them with lots of different books about the fact they've travelled the world and
I love the colour of the walls, by the way.
Yeah, well, it's the pictures that make it as well. And actually, I'll take credit for that colour because I picked that out. Okay. But no, I thought if I just do that, it's a bit boring. But this here, which is we do virtual tours. Again, we push this mainly in the commercial sector for day nurseries. Is something that we didn't think it would. We didn't think that would be a market that it was, but we're doing huge amounts of day nurseries at the moment, mainly because of the C word, which I'm not going to say. The drone, we use that for everything from photovoltaic panel and thermal imaging to make sure that they're working. I'm not on about buildings. I'm on about like 15 acres for argument's sake. But all the way through to things like bridge surveys. We did a couple of bridge surveys in Lincoln to save them having to get people abseiling down to check the structure of the bridge. But we also use that for marketing as well. So, we'll do sort of aerial shots and photography and things like that in the residential sector. Tends to be sort of on the upper market, so sort of £750,000 and above. But yeah, I just thought if I put them two there, it might show a little bit more in terms of the array of services as a company that we offer.
It's nice to have the toys as well and have them tax deductible. I did a similar thing when I bought this property behind me here, behind the blue car there, and before I turned it into this, when I was negotiating on it, I got myself £1,000 worth of a drone, which I've always wanted to have and never had been able to personally justify the cost of it. But since it was tax deductible in this case, I went for it. So I knew that there was a swimming pool on the roof that was all built in as well. So yeah, I don't think I've hardly used a drone, to be honest. But there you are. I have it at least anyway. Now, finally, we've got a question from Carol, I'm sorry, which is really sort of coming onto her flat issue, where she has no control on the externals of a flat. So, how does she influence the EPC on a flat for 2025 when she has no control about the externals?
Yeah, it's a good and a valid point as well. And, we're dealing with a client at the moment that's in the same position. In fact, I'm doing the analysis on his property tomorrow, where it is a system-built property and it's tile hung on the front and the back of the property, 3 stories high. It's got a flat roof, but they can't insulate the walls in terms of they can't do cavity because it's tile hung, but they can do it internally. Now, potentially in Carol's case, if it's a solid wall, yes, you can do it internally. What does Carol say there?
Sorry, commercial below, then 2 layers of underground parking.
Yeah, is it a solid constructed wall?
Do you want to join in, Carol? No, you're unmuted.
I think it is. It was built in the 80s.
Yeah, okay.
Late 80s, early 90s. And there is some insulation, it looks like, there already that's been...
How many blocks are there in the, how many flats are there in the block, Carol?
I think it's
is it
about
like
108. There's two blocks. There's about 180 flats altogether.
Okay, so the likelihood is that the freeholder is probably moving toward having something done, and I say that on the basis of the fact that there are a significant number of landlords and big building owners that we deal with, Freshwater Group for argument's sake, that own I think 4 or 5 huge blocks in Nottingham, and they're all stone construction, and they are going through a programme of basically getting them all externally wall insulated because of the MEES regulations. Obviously you can't hang your hat on that being the case. The only thing
it's like
yeah, I know, and it's like, if it's are you the top flat?
No, I've literally, there's 2 lower floors above me, commercial downstairs, and then under that there's 2 layers of underground parking.
What's above you? Is there another flat above you?
Two flats above.
Okay, and is it all electric heating?
All electric.
Yeah.
And at the back of it as well, there's a commercial complex with cinema, casino, foods.
Yeah, you see, you could potentially internally wall insulate it, but it's hugely disruptive. And of course, you lose an element of the volume of the building. I would suggest, and by all means, you know, if you get my details, email me, give me a call. I can perhaps go on Google Earth and do a little bit more looking at it to give you some more information. But I would suggest that if you were to install, for argument's sake, Dimplex Quantum high heat retention heaters, it's a mouthful, you would be edging ever so close towards being in a C category, even though you're in a non-standard construction.
Okay, interesting.
I didn't quite catch that. Can you repeat
what
you said? Hang on, let me just find a piece of notes. Right.
Well,
So
we can write it in the chat. They were Dimplex, weren't they?
Yeah, Dimplex. I don't know how to do this. Where's the chat? Where's my chat?
Well, we can do it.
Oh, somebody can do it then. So it's
Later, can't we? Yeah.
Dimplex Quantum high heat retention heaters.
There you go, Carol. All there.
There you are. Look, that's it. Spot on. But
as a slight other comment,
yeah.
What's being done to actually add to our electrical output to fund all these things that are now going to be driven by electric? Because we've got this, and we've also got electric cars.
Well, apparently they're supposed to be increasing or improving the infrastructure. The cynic or the conspiracist in me will say to you that the reason why they're pushing everybody down the electric route is because if they want to, they can just flick a switch off.
Yeah.
But that's not the professional view I should take.
It's a bit like smart meters aren't really smart. They're just there so they can time us by the hour.
Yeah. They can influence the price of electricity on a minute by minute basis.
I mean, would it be an option for I suspect that the property's held by a pension fund, and I wonder if they'd consider maybe doing solar panels or something, because there must be a lot of roof space.
Yeah, well, I mean, again, if you can encourage or promote the use of renewable technologies, in particular photovoltaic. The only thing with that is that you would need to get engagement from all of the apartments. But the problem with that is if you've got, say, 180 apartments, and the cost of installing that might only be £600-700 per apartment, but the percentage of the electricity that you're going to get back might be not a great deal and not significant enough for people to be it's the return on the investment is what it is when we look at things like photovoltaic and ground source, air source or wind turbines.
I mean, the pension fund have been good because they've renovated they've taken over control of the car parking and they've renovated it all and put low energy lights, but also triggered.
I know, PIR sensors.
Yeah.
Where is it, Carol? Is this in Coventry?
No, it's in Birmingham, Broadway Plaza.
Right, okay.
So it's where what used to be the old hospital that they sold off.
Given that it's a pension fund, potentially that could be a positive for you, I would have thought, but I'm not an expert there. Only from purpose of governance, really.
Well, it's interesting that since they've taken over the car park and started managing that, what used to have maybe 50 cars in it now is pretty well chocker most of the time.
Yeah.
So they're definitely being more practice. They've introduced the license plate reader for the parking.
Mm-hmm.
So
Brilliant.
that's quite a good introduction.
Well, given that we are on time, unless there's any other questions for Gareth, I mean, that was fantastically informative, Gareth. Really pleased that we managed to get you on today. And by all means, in the chat, when we finish now, pop some details in the chat about your company and contact details and everything else. But what I'll do is I'll also pop something on our own Facebook groups and everything afterwards so that people can contact you if they need to. I have to say personally that was far more informative than I woke up this morning thinking that this section of the day would be. So that's a really big thumbs up to you on that one. Thank you so much.
Thanks ever so much. I appreciate that.
Yeah. And so what I'm going to do, and by all means stick with us, and you can answer questions on the chat during the course. But I'm going to just stop your video now, and I'm going to bring in Stefan, who it has been patiently listening to what you've had to say, and I'm just trying to see if his video will come up soon. He may need to initiate the video himself. There we are. So we've got Stefan Daines. Hi, Stefan. Thanks a million for joining us today.
My pleasure. Thanks for having me.
We're only 4 minutes late, so how about that? That's not so bad at all. Thanks for coming and joining us. Hope you enjoyed that last section yourself. Stefan is a chartered insurance broker, and I think the first thing I can ask, as well as you introducing yourself, the first question I can ask of you, Stefan, is what is a chartered insurance broker, and how does a chartered insurance broker differ from an insurance broker?
Thank you. So a chartered insurance broker just means that there's, in the insurance industry, there's 4 levels of qualifications that you can do. So the beginner is a certificate, then you move on to a diploma in insurance, and advanced diploma finished by a fellowship. And so to become chartered, you have to have done the 3rd of the 4. So I currently have an advanced diploma in insurance. You also have to have 5 years experience in the industry. So that is a chartered insurance broker for you.
Yeah, and you know, across the sort of spectrum, in terms of, I mean, there are loads of insurance brokers, obviously all over the country. By the way, if you could get a bit closer to your microphone, we might hear you a little bit better.
Apologies.
Yeah, much better. Yeah, thanks.
Excellent.
So, you know, in terms of ratios of all the insurance brokers in the country, what ratio of them would be chartered?
That's a very good question. Not a huge number, but I suspect in the years ahead that's going to become a common theme. I suspect that the FCA, our regulator, are going to make it a requirement that more and more brokers, if they're giving professional advice to clients, and they expect certain standards and certain training to have been undertaken, as opposed to just years of experience in that industry.
Yeah, and obviously you're managed, and you have a code of conduct that is controlled by the Institute, as opposed to, you know, the big hammer, not as opposed to, but as well as the big hammer of the FCA, which obviously all insurance brokers have to be under that jurisdiction of regulation. But yours is more to do with a code of conduct and professionalism, I imagine. Is that correct?
Yeah, absolutely. I think it's fairly general across all insurance brokers. I'm not sure it changes too much for a chartered broker.
Right.
But generally speaking, yeah, but that applies to us all.
Yeah, okay. Well, I do, from my own past of insurance involvement, one of my more senior employees did want to become chartered himself, and he told me all about the work it took and how much studying there was and everything that was involved in it. And it was pretty impressive, I have to say. So if anything, you've undersold yourself on that one.
Well, there's a reason I've not gone for fellowship. I've done my dissertation at university, and for a fellowship, it's another dissertation. So
Right.
15,000 words is in top of my agenda right now.
So tell us a bit, where are you based, and what tell us a bit about your firm?
So we're based in Hertfordshire, just north of London, and we are a general commercial insurance broker. We also do a little bit of personal lines business. So personal lines would be household, personal motor. That would be 5% of our business, but 95% is commercial insurance. Landlord insurance is included within commercial insurance. So we look after accountants, solicitors, offices, motor fleets, professional indemnity, which Gareth mentioned just before. We look after tradesmen from one-man bands who hold a little bit of public liability cover for £80 a year, all the way up to contractors turning over 100, 150 million pounds a year, paying a lot more in premium. So yeah, but by volume, the most common policy we deal with is landlord insurance.
And talking about professional indemnity and liability covers, there may be some questions coming up from the audience, because a lot of our property people, they undertake some element of agency work as well. You know, whether that will be sourcing properties for other people, or whether that be acting as a sort of managing agent as well. Not necessarily in the same vein as a high street letting agent, but more taking on other people's owned properties and then operating them as managers in that way. So liability elements, that I'm sure there might be some questions coming up with regard to liability, with regard to that as well. But we were going to talk, one of the main things I wanted to bring insurance into the conversation today was because of having Alex on in the morning with regard to the difficulty it is in evicting tenants these days. We're looking at how a landlord might be able to de-risk their business a little bit. And the one question that we see a fair bit of people advertising rent guarantee. In itself, rent guarantee can be confused, because there are some people who just say, I'm going to guarantee your rent, which has nothing to do with insurance whatsoever.
Absolutely.
But I wondered if you could just tell us a little bit about rent guarantee insurance itself, and what that does and how that works.
Okay, so rent guarantee is an insurance policy where the insurer agrees to indemnify the landlord in the event of default of the tenant. If the tenant stops paying their rent. There are affordability criteria in order to apply for that product. So typically it would be that the tenant's gross monthly salary would have to be 2.5 times the tenant's monthly rent to be eligible. So it makes it unobtainable for DSS tenants generally, unless they have a guarantor. Some providers allow for that. There's quite strict stipulations as to the referencing which the insurer would mandate. So normally it has to be done by one of their approved referencing companies. One of the referencing criteria is subject to a satisfactory credit check. You would need an employer reference. You would need a reference from a previous landlord if there is one, photo ID, an additional form of ID, so a payslip, utility bill, bank statement. So there's quite a few hoops to jump through to even be eligible to get that product for your tenant. I think the comment I'd make about rent guarantee is it's changed massively as a result of COVID. So when COVID hit, the vast majority of rent guarantee insurers withdrew their products for new business. So if you already hold rent guarantee, you can still renew your insurance with them, albeit on very different terms. But to buy a new policy, it became extremely difficult. There are now some products that you can now get this cover again, but again, it's very different to what cover you used to be able to get before. So commonly before COVID, you could get cover for 6 or 12 months indemnity period. Now, all I have seen, all I can get is 6 months. The policy excess used to be 2 weeks, so that's the bit that you cannot claim for, the first 2 weeks loss of rent. Now that's the providers that we have access to that have re-released their products, that's now 2 months. And that 2 months is deducted from the 6-month indemnity period. So you're left with 4 months of cover available from the rent guarantee insurer. And the other caveat with rent guarantee insurance, I've seen a few providers where it is a requirement for cover that it must be possible to evict the tenant. So whilst there was a ban on evictions, the likes of, I saw Direct Line on their website where people had bought rent guarantee via Direct Line then said it's not currently possible to evict that tenant, and therefore the rent guarantee section doesn't apply. So it's not my favourite form of insurance personally.
Okay, no, I can see that. If you're only going to pay 6 months and 2 months of that is excess, you're not really getting a great deal for your money, are you?
No, that's my feeling. There might well be products available out there that offer better than that, but for the ones I've seen come back to the market, I mean, the premiums, it used to be common, anything from £50 to £100, £120. Now the premiums are...
What with the sorry, I'm just trying to get myself back into focus. What would the what are the premium changes? What would the premium be pre-COVID for a rent guarantee product?
So pre-COVID, normally around £100. I've seen them as low as £50, right. 100, 120. Post-COVID, we are commonly quoted £300 for that cover that we've just explained.
Yeah, and I've heard people quoting 2 or 3% of rent.
Yeah, I think that's through letting agent. So that works very differently. When you buy via an agent, they charge a percentage of the rent, whereas when you buy generally via a broker or online, it's a fixed fee.
Indeed, that was a letting agent product. That and that's interesting. So from a broking point of view, and you're being very honest when you're saying you wouldn't really recommend it, and it's not one of your favourites for that reason, but I do believe you've got almost an obligation as a broker to provide something that's an appropriate product for a landlord. And one might argue now that if it's taking you 12 months to evict a tenant for non-payment, as we've heard this morning from Alex, is it actually a case that brokers really, shouldn't really be offering this anymore because it's no longer appropriate?
Yeah, I completely agree. I feel uncomfortable with the products that I have available to me at the moment. I don't recommend them. I think there's other ways that you can deal with that. So if you purchase instead a decent legal expenses policy, not a rent guarantee insurance policy, just a legal expenses policy. Yeah. These vary massively from insurance to insurance, just because it says on the policy schedule that you have £100,000 of legal expenses. Unless you drill into what that is giving you within the wording, what sections of cover are provided, then it makes a massive difference. But under a legal expenses policy, you can have insurance for something called rent recovery. And what that gives you cover for at a much lower premium is the cost of pursuing the tenant in the event of rent arrears. So it doesn't guarantee the rent, it doesn't pay you the rent, but it does pay for the costs. If there's reasonable prospects of success, any legal expenses policy is subject to the
we'll come on to prospects in a minute, because that's something that everybody really ought to understand what it means. But with the rent recovery, what you might call add-on, because you wouldn't normally get this in any general legal expenses policy. You probably have to have something specific for it. But does it also cover possession, or does it actually, on the other hand, require that you're going for possession at the same time?
For rent recovery?
Yes.
you'd have to look at the individual policy and have a look. Generally speaking, so the product that I recommend for legal expenses cover doesn't just have rent recovery, it includes repossession cover. You have to be careful because a lot of the time where it looks like there is eviction cover, actually that would be for squatters. It would then exclude cover for evicting a tenant who should no longer be there, who's been served their notice. So again, it's really drilling down into the wording. So it would include rent recovery, repossession, dilapidation disputes, subject to certain criteria being met, tenancy disputes, contract disputes. So a decent legal expenses policy addresses a number of...
And of course, if you were to buy into one of these legal expenses policies now, for example, so long as the issue hasn't already arisen with your tenant up to this point in time, you would be covered. You don't have to do it at the beginning of a tenancy, for example.
Correct. The only caveat to that is that there is normally a 90-day cooling off period, in that there is essentially no cover for that first 90 days for certain sections of cover, where the insurer is trying to make sure that you haven't suddenly spotted something that's gone wrong, realise you haven't bought the cover, and then a month later.
And then it's happening, yeah. So
every renewal after that, you don't have your 90 days cooling off.
Yeah, and that's quite common in many policies, that there's this period of time after you've bought the policy before it actually works. I'm just going to, just with your microphone, it's coming and going a bit. If it's that thing on the wire, which it may be next, I don't know if that's what you're using, but we can hear you, but we have to sort of go a little bit closer to our speakers in order to do so.
Is this any better if we take these out?
I think it is actually. Let's see.
We'll try like this for a little while.
Yeah, no, I think that's actually better. So, so with so you can get a legal expenses policy, and then if you have the problem that we have learnt about this morning, and Alex has given us some pointers to, tenants not paying any rent, so you'll phone up your legal expenses insurers, and then that will actually cover the legal bill, which I know can be quite significant in terms of both getting possession of the property and actually recovering the rent. Now, let's take this step by step, because first of all, could we then go back to Alex and say, listen, we've got this legal expenses policy, we'd like you to act for us, you know, and then the insurer, would the insurer pay Alex, or do they have their own employees?
So for assessing whether there are reasonable prospects, the insurer will do that themselves. However, they are not able to mandate who you use as a solicitor. Right. Can you hear me okay?
Sorry?
Can you hear me okay?
Yeah, we can, yeah.
Just about.
Yeah, just about.
Yeah. They cannot mandate who you can use as a solicitor. However, they will have a maximum amount which they will pay should you wish to use your own solicitor. So that might be £100 per hour. If your solicitor is £150 per hour, the difference is left for you to pay.
Yeah. Okay. So you can't get the top barrister in the centre of London to act for you just because you're insured. I can understand.
Fortunately, not.
No. Okay.
Imagine that.
Nevertheless, I imagine that they've got to offer what would be a reasonable rate that, you know, a solicitor acting in that manner would normally charge.
But the amounts I tend to see is £100 per hour. It is the general going rate. I don't really see maybe 120, but it doesn't diverge much from that figure.
So if we were to buy this legal expenses insurance, it might be worth asking, you know, our favoured solicitor in advance, you know, what is his hourly rate, and if we bought this insurance policy, would he be happy to do it for that hourly rate in any case? Yeah.
Very good question.
Yeah, because of course, you know, there's an element of more secure debt, I suppose, for the solicitor in that regard, isn't there?
Sorry, go again with the question.
I was saying there's an element of more secure debt for the solicitor. If he may only be getting £100 an hour, but he knows he's going to get the money at the end of the day for the hours that he used, because he's billing an insurance company as opposed to billing a client in that regard.
I completely agree.
Yeah. So they might be quite happy to take a slightly lower hourly rate and deal with an insurance.
You'd have to ask a solicitor whether they'd take a lower rate.
No. So the situation is then, and as we've learned this morning with Alex, is that it could take up to a year now in order to get possession of the property because of the difficulty, and all the while the rent arrears is building up, and of course the legal expenses will cover the solicitor's fees for actually recovering that rent arrears as well as getting possession. Is there a point at which the policy stops? Because ultimately you could get a CCJ against the tenant. Often landlords don't actually pursue the rent arrears until after they get possession. But then they would get to a point where they've got the CCJ. But then there are numerous choices, and it could take considerable amount of time beyond that as to how to actually get an order, maybe an attachment to earnings order or whatever it happens to be, to actually get the money back.
I think that's why when you buy a legal expenses policy, you want a policy which has everything tied in together. You want one which is going to do the repossession bit for you, and it's also going to do the rent recovery for you. The only part where the policy would stop working for you is if there are no longer reasonable prospects. If the tenant was declared bankrupt, then the rent recovery bit, you might be decided that there are no longer reasonable prospects in pursuing the tenant for those arrears.
And if you've had the CCJ because you'd put the money claim in to the address that the tenant was living in, which was your property, and you're able to do that, and you've got the CCJ, but you don't know where the tenant has moved to, would the legal expenses policy then sort of turn around and say, well, we're not going to take it any further now because the prospects of success are too low to go further?
I think that would be down to the individual circumstances. I wouldn't be able to answer that. It would be very much down to whether the solicitor at that time believed there was still a 51% chance of getting some of these arrears back, or if you've fallen below that threshold, at which point the legal expenses policy then ceases to operate.
Yeah. So prospects of success equals 51% chance of success, basically.
Absolutely.
And who makes that, that quantitative?
How they do it is another matter. So the insurer makes that decision, but they would instruct one of their panel solicitors, so DWF, for instance, and they would look at all the circumstances there are at the start and decide whether there are or are not reasonable prospects at that time.
And if you were using your own solicitor and he felt that there was 51% chance of success and the insurer was sort of suggesting it was 49, then you might be in a slightly better position than if the insurer is using their own solicitor, perhaps.
I've had many occasions where the insurers come back and declined a legal expenses claim in the first instance, only to change their mind after a little bit of persuasion. So yeah, I wouldn't be alarmed initially if they say no. But yeah, if you can't get your own solicitor to confirm there are reasonable prospects as well, then you're probably not onto a winner.
Yeah, and which is probably why council's opinion rarely goes above 55% chance or below 45% chance in any case.
It is funny, it always ends up around the middle. And often that depends on who's paying the bill, but okay, no, that is interesting. So now a general legal expenses insurance that you might get if you were, say, a member of the Federation of Small Business, for example, would that cover this sort of thing, or is it an add-on for a landlord? I don't know what their product covers as standard. All I would say is when you buy your landlord insurance, the option to tick down legal expenses. A lot of the time they are very...
Yeah, we're losing you completely now. I'm sorry, sound-wise.
Oh dear.
Yeah. No, I can hear you again now.
Can you try again now?
Yeah, try again now.
Okay. I don't know what that policy covers as standard. All I can say is when you add legal expenses cover to your landlord's policy, it's not uncommon for it to be a very basic level of cover and not include a lot of the key sections that I referred to: repossession, rent recovery, dilapidation, tenancy disputes, those sorts of things. You'll often find there's eviction of squatters, there's tax matters, but not a huge much else. Yeah, so it really comes down to looking at not just buying the £100,000 limit, but looking at what you are getting for that limit.
Yeah, yeah. Now, you're probably not aware that the members of Unity, of which we have many guests listening today as well, so not everybody in this chat is a member. The members of Unity do benefit from a legal expenses policy as part of their membership. But the cover that we're talking about, which will cover rent recovery, is not included in that because, of course, you know, this is a relatively low-cost policy for a group of people, whereas, you know, the provider would no doubt provide an additional, but for additional premium, an individual policy that would cover things such as this. Yep. Similarly, with contract dispute cover, that there is a small element of contract dispute cover within the Unity legal expenses policy, but not sufficient to cover a development of 4 houses, for example, you know, because that is a much higher risk situation from a legal expenses position. I would say that the main benefit of the Unity legal expenses, which is completely full and is the tax investigations insurance element of it, which the members definitely benefit from. And I've arranged that particular cover in such a way that because property people tend to have many different entities that they operate through, whether they might be doing an SPV for one development or have some landlord properties in sole trader names and other in limited companies, that the Unity membership cover will cover all of the property interests regardless of how many entities. But it is limited, it is restricted, and so this is why it's quite interesting to learn about legal expenses insurance, and you know, to highlight to members that it is still something that they may need to be looking at if there are specific aspects of their operation that they want to have covered in that regard. You know,
I agree, it's very important
cover. And so I would say that this. What we're getting to here from this conversation is that the rent guarantee covers sound to me like they're not worth the money, based on the fact that they're only covering 6 months of arrears and 2 months of that is taken away in excess. That's not to say all covers will be like that. There may be other covers out there which cover more but will cost more. But it does seem to me that it would be worthwhile to, in risk managing your business, to actually have the legal expenses cover that would actually deal with possession and rent recovery.
As a comparison, for the cost of the legal expenses, which I explained relatively singing and dancing, that would be £100 for a year, and that would include multiple properties under the one single policy, up to a rental income of up to £100,000.
And would that matter that 2 of those properties are owned personally and 8 of them are owned in a limited company?
So the way I would deal with that is I would check with the insurer, but both would have to be named on the title.
Yeah.
As long as they are all connected in that the individual owners are also the directors and shareholders of the limited company, it should be fine. If we start to muddle those up, then we should be looking at separate policies.
Okay. So £100 under the current circumstances could well be £100 well spent, I would have thought, in that regard. It's not going to guarantee your rent. It's not going to give you your rent when the tenant goes into arrears, but it will pay for either one of the insurance solicitors or a solicitor of your choice, subject to limits on hourly rate, with regard to doing the work and actually getting possession for you in that regard.
It might well be that the rent guarantee product is best for a tenant that you're particularly nervous about, that satisfies the affordability and referencing criteria, and you would like that little bit of comfort. But it is only a little bit of comfort it gives you, unless there is a different product out there which is more generous than the ones I can find.
Yeah, and I do think that you do need somebody on your side in this, because we all know what the insurers can easily reject claims on whatever reason that they choose, and sometimes rightly, sometimes mistakenly, with the limited information that they've got. But it's often not wise to just accept them at face value, but to actually challenge these decisions, and often they can reverse those decisions further down the line, as far as that's
And this is another benefit of buying the legal expenses policy as a separate policy.
Right.
If you buy a separate legal expenses policy under the contract dispute section, if your property landlord insurer refuses a claim unjustly, you can use your legal expenses policy in the contract dispute section to challenge that incorrect repudiation. If you add it onto your legal expenses, if you add legal cover onto the same as your landlord policy, then the insurer isn't going to pay to challenge themselves. So by separating the two policies, you actually have another layer of defence. And believe it or not, we have used that.
Very good. So basically, you basically get one insurer and you use it as guns against the other insurer in that regard. Yeah.
Absolutely.
Yeah, very good. Is there anything else we should be aware of or concerned about or consider with regard to this?
I think I'd more talk about landlord insurance generally as opposed to legal expenses, which I think we covered quite thoroughly. And just being aware of the different covers and obligations of disclosure. Standard construction is one that gets me. Everyone thinks their property is standard construction. A flat roof is not standard construction. If it's a felt roof, insurers deem that as non-standard construction. It should be declared. They will often apply conditions about inspecting flat roof every couple of years. Sometimes every year, it varies from insurer to insurer. But if we don't tell the insurer about the flat roof and there's water ingress through that roof, then the insurer will retrospectively apply those terms. Come a claim and you'll probably find you won't have cover. Or if the insurer would never have written a property with a flat roof, they can outright refuse the claim. So it's just important to make sure timber frame properties, listed buildings, any portion of a flat roof needs to be declared to the insurer.
And you've just almost answered a question that was in my mind there. Any portion of a flat roof, because of course many terrace properties would have that flat roof extension going out the back, which may only be, 4 square meters or something like that.
Yeah, I'd still be declaring 5% flat roof, because if you have water ingress through that little element, they're notorious for that. We're then in the grounds of arguing with the insurer as to whether that accounts for a flat roof. Best off to declare it as a 5% flat roof, and it's out in the open. Arranged.
One of the things that's very frustrating for landlords is this self-declaration of value, where the insurer refers you to the RICS website, but actually if you go to the RICS calculator, the questions that they ask are not really questions that most property owners would be able to answer.
So is this to do with the rebuild declared value?
Indeed, yeah.
Yeah, so this is a minefield, I agree. And the insurance industry makes it even worse for landlords by their terminology. So often when landlords buy insurance, it's on a day one uplift basis. And that means you have a building declared value, and then that is uplifted by a percentage, and then you have a building sum insured. And any landlord would think they are insured for the building sum insured. That isn't the case. The building declared value needs to be the cost of rebuilding the property on the first day of the policy.
Mm.
The day one uplift, 30%, whatever they've given you to give you the building sum insured, is to cover the cost of inflation. So let's say after you buy a policy today, and your building declared value is 200,000. It burns down on the last day of the policy. So we've had a year's worth of inflation. By the time you actually get to rebuild that property and you've cleared the site, you've gone out to tender, you've got all your plans drawn up, it might not be rebuilt for 2.5 years from the date that you picked your building declared value. That's why you have a building sum insured, is to protect you for the cost of inflation. In the 90s was running at 10-15%. So you would have been underinsured without that protection. But most landlords look at their policy, and I had this discussion just yesterday, say, oh no, my building sum insured is 300,000. No. Your building declared value is 200,000. That needs to be the figure that is enough to rebuild the property on day one, including clearance of debris and all professional things.
Right, okay. Now that's very interesting. And of course that can mean that some properties, particularly terrace properties, which will be expensive to build, a mid-terrace, could actually have much higher values or sum insured values than the value of the building themselves.
Yeah, and then we go into the condition of underinsurance. What happens if you're underinsured? Then the insurer pays a proportion of the claim according to the amount of underinsurance. So if you're 50% underinsured, the the insurer is only obliged to pay 50% of any claim, whether that's a £5,000 claim, a £50,000 claim, or a full value claim. They will reduce it proportionately by the amount of underinsurance. So when it comes to choosing your rebuild declared value, you mentioned the calculator there is. So one of the things we offer our clients is a remote desktop valuation. So there is a small fee. We don't charge it. It's the valuation firm that charges it. But for £112, you can have a rebuild valuation bespoke to your property, RICS approved, that gives you the rebuild value for that property.
And question from Carol, which I was going to answer in any case as part of the conversation, was to say that, of course, if you're overinsured, you pay more premium because...
Yeah, that is the punishment you... Yeah, that's the punishment you...
Yeah.
So,
but coming back to this value, and you know, this brings in another third insurance, which is obviously professional indemnity. If you are putting out that to a RICS valuer who's going to do the valuation for a fee in order for us to put that on our policy, what if the insurer then turns around and says you're underinsured in the future? Is that something you can then recover back from the valuer?
Yes. Yeah, so the valuation would normally say we recommend you get this revalued every 2, 3, however many years. But if they have misvalued the property and you are underinsured, a lot of insurers will actually waive the rights of average, the condition of underinsurance. They won't apply if you have a RICS valuation within the last 3 years.
Right. Okay.
So it protects you. And on top of that, you can also then sue the person who's...
Yeah, you could, or maybe the same insurer is providing the professional indemnity to the person. Okay, I'm getting it. Yeah.
Possibly.
But that actually is quite a good protection, isn't it? You know, that for a small fee, you can actually get this valuation protected. Do they over-egg it? Does it end up costing you more in premium?
I mean, I think what we find by the ones that are done is that a lot of people are underinsured and they don't deliberately underinsure themselves, either because they haven't understood the building declared value and building sum insured, the difference. The company that we use is called Rebuild Cost Assessment. So you can go direct to their website and enter your properties and pay for the valuation, but they just charge slightly higher people going direct as to going via a broker and just see.
Okay, and because we can't hear you very well, was that 120, 112, did you say?
112.
112, okay.
And that's including VAT.
Yeah, per property though.
Per property, but if you have multiple similar properties, you could always do one and then use that as a basis for deciding the others.
Yeah, fair enough. At least you're not going to be too far out, are you? In that.
Yeah.
So that's how you do your flats, Carol. You just pay for one of them, you know, in that regard. So, do we have any questions coming in from the group? This is interesting stuff. We'll just see. Was there anything else that comes to mind yourself, Stefan, that you wanted to convey?
No, just, I mean, make sure you tell the insurer if there's any units that are unoccupied. People don't realise that if you have a HMO and 1 unit out of the 4 or 5 is unoccupied, the insurer wants to know. You have to tell the insurer. And there's unoccupancy conditions that they will impose on it that might already be within the policy wording, requiring inspections, utilities isolated, some of which you won't actually be able to comply with. So there needs to be a conversation between landlord and insurer, or broker and insurer, to say, well, we can't isolate the utilities. There's only 1 unit that's unoccupied. The rest of the units are still using the electric, the gas. But unless there's these discussions, there's conditions in the policy wording about unoccupancy and turning all the utilities off and having regular inspections that we fall foul of. So yeah, tell the insurer in the event of unoccupancy, DSS tenants, student insurers want to know all of that stuff, and make sure there's cover for malicious damage by tenants. It isn't always obvious until you drill into the policy wording of whether there is cover for that. Malicious damage by tenants is an important section of cover.
Okay, so that's not just for self-contained flats then. You're saying that even in an HMO, if 1 room is not let, you really ought to be telling your insurer about that.
If you read the wording of most insurers, they will say if any portion of the property becomes unoccupied, the following conditions apply. And then they will list the 10 different conditions which they expect immediate notification, utilities turned off. Well, we cannot comply with them. And the insurer must know we cannot comply with them. I've had conversations with solicitors, and they'll say the only way to get around it is to have that conversation and the insurer confirm that they waive certain sections of those unoccupancy conditions. They will still want you to inspect it every week, but they might agree to waive turning off the electricity and gas because clearly it just can't be done.
You can't do that. I understand. I understand. I wasn't aware of that, and I'm fairly certain that I'm amongst the majority of landlords that would not inform their insurer when, you know, one room in an HMO was currently. I mean, obviously every room is empty for a short period of time. Is there a period of time when practically you wouldn't?
So it would, again, drilling into the policy wording, what is their definition of unoccupancy? Normally 30 days, sometimes 45 days. So it could well be that they've drafted their policy wording to say as soon as your property becomes unoccupied, you must notify us immediately. And their definition of unoccupied is 30 days, any unit, any section of the property that's been unoccupied, 30 days, 45 days. So that would be your period of grace.
And it is good fun reading policy wordings. You find all sorts of spelling errors and grammatical errors and all sorts of errors. And really interesting. And there's stuff that's been pulled in from another policy that is in there that shouldn't be in there. So you can find some really interesting stuff, can't you? One I read the other day on rent guarantee actually was using the word avoid instead of the word void. You know. But there we are. Carol said, is there any easy way to compare cover or a standard to which cover is provided?
It's going to be a bit of self-advocacy, but it's to have a broker who knows what they're talking about and will know which insurers will give good malicious damage by tenants cover, which ones don't. It's just down to knowledge. We have 22 landlord insurers we use, and I will be able to, I know which ones give what cover. On Go Compare, I don't think it tells you in that much detail unless you're going to open policy wording. So.
And does a landlord pay more for a broker's service, or does that come, you know, is that the insurer's cost?
So normally it's the insurer's cost. So we receive a commission from the insurer because we place business with them in volume. So there is no broker fee that besides a small admin fee potentially that would be applied. So, and normally I would say relative to online comparison sites, I would say normally it's cheaper via a broker.
And what about your relationship with these insurers? I mean, who's the most important thing here? If there's a claim and the insured is not happy with what the insurers are saying, is the broker going to be representing the insured a little bit more? Is there more chance that the insurer is going to get their way with the insurer?
100%. So if there's an AXA claim that AXA refused, we will have a renewal with AXA the following week worth £10,000, and that we'll be waving that in front of them and saying, well, you get your finger out, otherwise there's going to be issues on your renewal. So we have a book of business that we can use as leverage where we can, but there's nothing we can do where the insurer is genuinely right in declining a claim.
Yeah, you've got to take a sensible middle line there, haven't you? And back what you believe is the honest case as far as that's concerned. No, that's very, very interesting. So, has anybody else got anything for Stefan?
Just picking up Carol's question there. So I assume you avoid those that are poor at paying. So there is always a conversation to be had with the policyholder, the landlord, about what they want out of their insurance requirements. If they want the cheapest of the cheap, then we can absolutely do that, but it will be a low quality insurer. It wouldn't be my recommendation. I will know straight away when I go to market and I get my quotes in who is a good insurer, and they will be the ones I recommend. However, if my instruction is to get the lowest price possible, then I can do that as well.
I did see a question on a forum this morning, as it happens, with regard to rent guarantee, and they said that I have rent guarantee insurance. I had it before the tenant took up the tenancy for that tenant and everything, so everything checked out fine, the references and everything else. But the tenant has since lost their job and now is on benefits. Am I still insured?
They should be. So most rent guarantee policy wordings have the affordability criteria, and it says as at the inception of the policy, because after all they are covering the chances of the tenant becoming unemployed and then unable to pay their rent. So I'd be very surprised if they could avoid a policy based on the change of circumstances mid-term. They might not want to renew the policy, but they should be dealing with that claim as far as
interesting, because I think that's something that's happening probably quite a lot at the moment. So that is an interesting situation where, and again, you've got this situation where when you're doing a buildings insurance or whatever, they're asking, is your tenant DSS or otherwise? And you might say otherwise, but next time around they will be DSS perhaps in that regard. Still using the term DSS, it's used widely still, isn't it?
It's funny that insurers are allowed to do so and to decline quoting on DSS tenancies, whereas landlords are supposedly shouldn't be advertising for no
well,
DSS.
I suppose in a way it's just a pricing thing between the landlord and the insurer, and it's not directly discriminatory against the individual, is it, in that regard? But there was an issue. There was an issue a few years ago with women's premiums on driving, wasn't there?
Absolutely, between male and female drivers, and it was held that insurers could not discriminate and charge more for a male young driver than a female young driver. I can't see insurers' position being sustained in the longer term in this field.
No, I know that the banks are under a lot of pressure at the moment because their mortgages preclude renting to DSS. And that's a bit of a problem. So there's an indirect discriminatory situation going on there as well. So Joanna says, regarding home insurance for a buy-to-let property, so that's property insurance, I know that we should tell the insurer when it's empty for some time, but if the tenant doesn't let the landlord know and something happens during that time, who's responsible?
Good question. So there is normally a provision in the landlord policy which says essentially that if the landlord is not aware that the property is unoccupied, they are not adversely affected by their lack of knowledge.
Sure.
So you should be okay. But if it was 6 months or 9 months, I'd be a little bit concerned as to how it being unoccupied. And the argument with the insurer is going to be harder to have, but absolutely would be.
Yeah, and actually I had a situation myself where for some very strange reason in this terrace property, the washing machine was on the upper floor in the sort of landing area in a cupboard. And I think what had happened is that the tenant pulled or the door of the washing machine wouldn't open, and that happens from time to time, probably to do with the cycle of the machine or something like that. And anyway, he pulled very hard and he didn't manage to open the door, but he did manage to pull the machine off the wall, and water just spurted out from the back of the machine. And instead of dealing with it, he packed his bag and ran. And it was discovered by my agent 3 weeks later, after the ceiling had collapsed and the water was still pouring out, so but the insurers, although I had massive arguments over value and all sorts of other things, and they did pay on that one, so yeah. So Joanna's saying my question is more regarding the tenant's Christmas break, so I'm on holiday now or something of that nature.
Yeah, so again, as long as the unoccupancy conditions in the policy wording, say 30 days, 45 days, then you should be okay for those sorts of periods. Again, it comes down to whether you know or don't know. If you don't know, you can't advise the insurer. If you do know, then you need to look at what duration there is of unoccupancy as to whether that triggers a notification requirement to the insurer. Fantastic.
That was really, really interesting stuff. Thank you very much. And that brings the sort of formal element of today's conference to a close. So what we're going to do now is just allow people into the room. By all means, Stefan's still here. He can read your questions in the chat, or you can come in and ask them directly. But please allow yourself come back for general chat and networking. I'm just going to nip out in a second to get a drink of water and come back to join you. But thanks very much indeed, Stefan, for your time. Really appreciate that. And please, if you pop your details in the chat box there, Stefan, so that we know how to contact you. And I'll also put that on the Facebook group as well.
Thank you very much.
Yeah. So there's always a pregnant pause at this point.
So I've just put in the group a link to the rebuild valuation service that I mentioned.
Oh, excellent. Thank you very much. Yeah. So we're now into our cafe mode now. So please join in and start chatting away. I'm turning the recording off.